Item number 1. Item number 1.
Item number 1, I am for the respondent, my lord, Bharat Petroleum.
All right. None appears for the petitioner. Dismissed for non-prosecution.
I am for the petitioner. Item number 1.
Tell us.
Yes, my lord. The thing is that I have filed an application for amendment, which is very simple amendments, my lord. So your lordship may please allow the amendments to incorporate in the writ petition.
What is the amendment, sir?
The matter is about an oil-rich company having the lead in its favor from me, my lord. I am the lessor, and oil-rich company is the lessee. The first lease deed was executed in 1963 for a period of 10 years. And after that, they entered into a renewal lease deed, my lord, from 1973 to 1993. So after 1993, they have no right, but they claim that a statutory right they claim. They have the power under the statute, that is Caltex Acquisition Act, consequent to which it emerged with the Hindustan Petroleum Corporation, HPCL, here the opposite part number 3, HPCL. So, in my view, the present writ petition is thoroughly maintainable, and since they claim that their statutory right is involved under the Caltex Acquisition Act,
So this should have been a civil suit. Whether the lease should be renewed or not, how is it a writ petition, sir?
I'm not audible, please.
How is it coming as a writ petition, all this renewal of lease and all that? Is he able to hear us? Yes.
And
Mr. Jena, are you able to hear us?
2004 is the writ petition, 2019 is the amendment.
I know. Is he able to hear us, Mr. Jena?
Mr. Jena.
May I pray that your lordship may take up the matter after beginning of the hybrid mode, my lord?
Hybrid mode will begin on 7th, sir. All right, at the request of Mr. Jena, list on 9th. There will be no further adjournments in the matter.
Lord,
Yes.
may I pray that let him serve copies of all these applications he has filed.
All right, meanwhile, the application,
And
IA
all
number
these
6,
copies
copy
have
of the
been served
application
already, my
IA
lord.
6619 of
It is
2019. Sir, please serve another copy. Be served on counsel for appearing for the opposite party.
HPC.
And another
I'm
copy may be served to Union of India, madam. I am appearing.
Sir, we are saying opposite parties.
My oblige.
My lord, may I please, my lord? All these copies have been served.
Mr. Jena, should we record that you will refuse to serve?
And copies of which petition? Entire petition and
No. The IA, sir. You have filed an IA for amendment. They want copies of that IA.
the amendment petition copy, my lord.
Yes.
Yes, my lord, I will serve by one
All right.
time may be given and matter may be taken up, my lord, in the beginning of the hybrid mode.
Hybrid mode begins on 7th. We are taking it on 9th. All right.
Item number 2.
Obliged.
Item number 2.
None appears. Dismissed for non-prosecution.
Item number 3.
Item number 3, my lord, on behalf of Mr. Satpathy, no instruction.
Counsel, the petitioner states that he has no instructions. Dismissed for non-prosecution.
Item number 4.
Yes, in item number 4, I am for the petitioner.
Yes.
Just today, I have filed a short note of submissions. Probably might not have reached your lordships.
We'll pass it over, sir. We'll pass it over.
Okay, madam. Or your lordship may take
Get
it
that
on
note.
8th,
How have
9th.
you sent the note, sir?
The Dropbox.
No. You can send it by WhatsApp or by email, sir.
That, I will try, my lord, because
No. We are passing it over. If we don't get the note, we'll carry on with the matter, sir. It's up to you.
I have no difficulty, my lord.
No. So we'll pass.
Can it
How
be
long
on
will it
9th?
take? How long will the matter take?
It will not take much time.
So we'll pass it over, sir.
Sir,
Item number 5.
May it please the lordships.
Yes.
Whereas item 5 is covered by your lordship's order dated 9/1/2019. I could not. And
Satpathy,
Mr.
in fact,
Satpathy,
this appeal was admitted long ago. A question of law has also been
Yes,
raised. Ah.
yes,
So no point in
And-
now going back on the remand.
yes.
No, tribunal, I'm just submitting tribunal has directed. Tribunal has
No, no,
Whatever,
directed.
sir, whatever. Now the matter has been pending here for
And
17
this-
years.
Yes,
And
yes.
this honorable court, my lords, hold that the tribunal grossly erred in remanding the matter.
Correct.
And Mr. Satpathy appeared in those cases on 9/1/2019. I'm just placing learned counsel for the respondent, Sri T.K. Satpathy, has supported the order of the assessing officer and submitted that the tribunal has only remanded the matter back to the assessing officer for adjudication.
Yes.
In our considered opinion, the tribunal has committed serious error. We have gone through the record. Admittedly, the order of the tribunal, which was relied upon by the assessee, was not reversed by any higher authority or forum, that is High Court or Supreme Court. In that view of the matter, the tribunal has seriously committed an error on remitting the matters back to the AO. At the most, tribunal ought to have accepted the principle and allow the assessing officer to make assessment on the basis of the tribunal's judgment referred to herein before. In such view of the matter, the question is answered in
So we'll
favor
say
of
it's covered by that, Mr. Satpathy. We have
Yes.
a copy of the order now.
yes,
Now,
9/1/2009.
While admitting this appeal directed against the order dated
Order dated 3/9, I think.
3rd
2000.
September 2003, passed
Yes.
by the Income Tax Appellate Tribunal in ITA number 199/CTK/92 for the assessment year 1987-88. This court, by its order dated 10th January 2005, framed the following question of law for determination. He produced the question in that order of 10th January 2005. Paragraph. In three other appeals, being ITA numbers 13, 14, 15 of 2004, involving the same assessee, right?
Yes,
Yes, ma'am.
ma'am.
Same.
But for different AYs. This court has, by order dated 9th January 2019, allowed the appeals and set aside the remand order by answering the question of the ITAT by answering the question in favor of the SEC and against the department. In that view of the matter, the question in the present appeal is again answered in favor of the SEC and against the department. The impugned order of the ITAT is set aside. The appeal is allowed in the above terms, but no orders to pass.
Obligement.
Item number 6. Item 6.
Lordship may kindly take up. There are three identical appeals.
Yes,
Lordship, may I pray your Lordship may kindly take up item number 221 of 2004. And
Right.
the question of law is given, that is, Lordship will kindly see, that is dated 8/5/2017 balance.
right.
Mellors, the questions are like this: whether in the particular facts and circumstances of the case, rejection of books of accounts and estimation of profit can be said to be legal and proper. Whether the ITAT is legally correct in holding that the rejection of books of accounts solely on the ground of non-issuance of sale memo is proper and justified. Well, here, my lords, I have got by purchasing Moha flour, I have some outlets, country liquor outlets, my lords. My lords, I maintain this sale register, purchase register, and these are verified. These are verified by the excise authorities. And that also your lordship will find in 221 of 2004, Annexure 3. That also is there. Annexure 3. That time. Annexure 3 of the order. Yes.
Even this is gone.
Yes. Annexure 3, my lords. Sorry. Annexure 3A, 3B, and 3C at page 154. Of,
1 minute, Mr. Rai. 1 minute.
Yes,
1 minute.
yes. ITN number 222.
Yes. We just there is some problem with my monitor, so just
Yes.
Ah.
Sorry, my lord. Sorry. Can I proceed, my lords?
yes, please. Yes.
Yes. Now the assessing officer, my lords,
Yes.
without finding any fault with
Yes.
my books of accounts,
Yes.
just on the ground that I have not given sale memo, that is the maintenance of sale memos, my lords, he resorted to base judgment assessment by making an estimate.
Right.
Now, against that assessment order, I went to the first appeal. Lordship will kindly see in IT appeal number 222 of 2004, Annexure 2. Annexure 2 at page 22, it starts. Sorry. Yes, my lords. Page 22. And the relevant portion I'll bring to your lordship's kind notice. That is at page page 20.
These, Mr. Rai, these three are different SSCs. Are they related firms or something?
No, well, there's different assessees, but the identical question. They have been common order has been passed by the ITAT because the common CIT appeals order is also same. Assessing officer order is also same. So they belong to only one place.
Oh, I see.
Okay, can I draw your lordship's kind attention to page 23 at paragraph 1.3.
Yes.
Submissions of the mailers got it.
Yes.
Submission of the appellant have been carefully examined and considered. It is true that the AO had not pointed out, this is very important, mailers, any specific omission or commission, nor cited any specific instance of irregularity in the books of accounts. The only reason banked upon happens to be non-maintenance of evidence to support the purchase and the sales. Though the appellant has argued that non-maintenance of sale memo could not be the only basis for rejection of accounts, it has to be mentioned here that inflation of purchase and suppression of sales are the two ordinary methods of suppression of profit. Full stop. While purchase from villages and local hearts might not be supported by printed bills, element of inflation. Well, may I say here that these country liquor are sold to the tribal people purchase it. So they don't insist. If I cannot insist upon to give
Sales
the
memo.
yes sale memo, and I'll again similarly in the case of sales, it is seen that excise department has fixed the minimum sale price only, even if the appellant to charge even if the customers were financially weak and would not insist for bills, there was no bar on the appellant to change higher charge price higher than the minimum price sale is fixed by the government. Therefore, there was also possibility. There was possibility of suppression of sale price as regards production of evidence in support of the expenditures. It is true that the appellant did not submit all the evidence, though major ones were produced during the assessment proceeding. In view of these reasons, the AO gave a finding that correct profit could not be deduced from the accounts as maintained. The finding and is found valid. The AO was justified in rejecting the books of accounts by resorting to the provisions of section 145 bracketed 3 wrongly bracketed 3 wrongly mentioned in the order of as 145 bracketed 2. It is it is worth mentioning here that in the cases of most of the assessee carrying country liquor business, rejection of those books of accounts and estimates of the income had been offered in appeal even at the level of the ITH. So this is the reason, and your lordship will kindly see the last annexer 5, the same tribunal for the latter years has allowed. That is
2001-2. Yeah,
yes,
for 1-2 they were allowed. Correct.
Yes, that has been allowed. Now,
Right.
my lords, I'll cite some judgments, including this honorable court. That is, my lords, the first one I have given it to the courtmaster,
Yes.
Ramchandra Ramnivas versus State of Orissa. Here, my lords, I am just reading the placitum maintaining of books of accounts, whether tribunal was justified in rejecting books of accounts merely on ground of low percentage of profit when accounts otherwise had no defects. Here, my lords, the CIT appeal categorically has said the assessing officer had not brought any instance that the books of that there was any wrong entry or is unreliable. No single instance blaming any commission or omission on the part of the appellant. Then, my lords, avoidance of tax liability, so and so. Then this honorable court said, we accordingly, last para, accordingly, the question in negative in circumstance, there will be no other cause. Before that matter, the tribunal took the wrong view in rejecting the books of accounts merely on the ground of the rate of profits as shown therein was low. That is, your lordship will see the last one. Paging, I have not done it, my lords.
No problem, no problem.
My lords.
St. Teresa's Oil Mills versus State of Kerala.
Yes, yes. There, my lords, St. Teresa Oil Mills also, the estimation was made because there was higher expenditure of electricity. So,
All right.
therefore, the estimation was made ignoring the fact of other things. So, my humble submission, there are also other judgments. Muhammad Umar versus Commission of Income Tax. That is, my lords, the second one is of Patna, Honorable Patna High Court. There also, tribunal held that defects as pointed out in earlier as still being there, revenue authorities were well justified in rejecting books account, estimating net profit. Then, my lords, the Honorable High Court authorities, they have also held that because of the Honorable High Court has relied on other judgments, that is RB Bangsila, RB Chan Spinning and Weaving Mills. The percentage of dead loss of cotton is high in a particular year cannot lead to an inference that thereby there has been a suppression of the production in the spinning mill. So also in the case of R.B. Jesaram Fatehchand, and this is the law they have said, and they have allowed the application para 7. I must answer the question in favor of the assessee, para 7 matters, and against the department hold that on the facts and in the circumstance of the case, the finding of the tribunal upholding the rejection of book profit shown by the assessee was vitiated by reason of its reliance upon suspicion, surmises, and also irrelevant materials. I also hold in the circumstance of the case that the finding given by the tribunal that the sales made by the assessees during the relevant year was unverifiable is not based on the materials on record and is an arbitrary finding. That your lordship will kindly see paragraph 7 of the Patna High Court judgment.
Yes.
Then, my lords, there will be only repetition of the judgments. Commission of Sales Tax, Vishnu Chandra, Bipin Chandra, same thing has been repeated. That is a Allahabad High Court judgment.
Who's for the department?
Yes. Mr. Mahapatra.
Yes.
My lord, I am appearing, my lord.
Yes.
In this case, my lord, the relying on the non-submission of the entire documents, my lord, the Lord AO as well as
No, but if you're making sales of country liquor to tribal people, where's the question of sales memo now?
yes, my lord, that is
Yes. That's very obvious, isn't it? All right. You say these three appeals arise from similar facts and circumstances, and the questions of law are also identical, and accordingly are being disposed of by this common judgment. As far as ITA number 221 of 2004 is concerned, it arises from an order dated 30th June 2004, passed by the Income Tax Appellate Tribunal. 23rd August 2004, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80. In ITA number 542/CTK/2003 for the assessment year 1998-99. While admitting this appeal, by order dated 8 May 2017, the following two questions of law were framed by this court for determination. Copy both those questions. As far as ITA 222 is concerned, it is directed against an order dated of the same date, that is 23rd August 2004 of the IT80. Again for AY 98-99. And in this appeal as well, by a separate order dated, no, this we have not yet framed it as question, no? Full stop.
No.
Since the question involved is identical, this appeal is admitted, and the same question of law is framed in the ITA 221 of 2004 is framed in the present appeal as well. Paragraph ITA 223 of 2004 is directed again against the order dated 23rd August 2004 of the IT80 in ITA number 541/CTK/2003 for AY 98-99. This appeal too is admitted, and the same questions of law. Sorry, this appeal was admitted on 8 May 2017, and by this court, and the questions of law framed were identical to the questions framed in ITA 221 of 2004. Paragraph. The background facts are that each of the SSCs is a partnership firm deriving income from sale of country liquor. Full stop. It must be noted at the outset that as regards the AY 2001-2002, the ITAT has accepted the books of accounts of all these three SSCs and has allowed their appeals, setting aside the orders of the assessing officer bracket AO and the Commissioner of Income Tax bracket appeals bracket CIT bracket A, affirming the said assessment orders. Paragraph. It is seen in the impugned assessment order, which is identically worded in each of the cases, that although the AO accepted the fact that there was nothing wrong with the assessee's books of accounts, only on the ground that sales memos were not filed, the books of accounts were rejected by the AO. When the matter traveled in appeal to the CIT bracket A, it was noted
Para 3.3 minutes.
in
3. Page 23, para 1.3, sir.
sorry,
Para page
1.3 that open quotation, it is true that the AO had not pointed out any specific omission or commission, nor cited any specific instance of irregularity in the books of accounts, unquote, and that the only reason for rejection was that open quotation, element of inflation in purchases or incorrectness of purchases could not be ruled out, unquote. Full stop. Likewise, it was again surmised that, open quotation, there was also possibility of suppression of sale price, unquote. It is therefore plain that both the AO and the CITA proceeded on surmises and conjectures with no supporting material to justify the rejection of the assessee's books of accounts. Full stop. The ITAT, having accepted the assessee's accounts in the subsequent, for the subsequent assessment year, 2001-02, for some reason, did not accept it as far as the AY in question. Full stop. Paragraph where the issues of sale of country liquor to tribal populations, to expect the assessees to issue sales memos is not even realistic. Full stop. Importantly, since the books of account of the assessees in the present appeals have been accepted, and for the subsequent year by the excise department, and for the subsequent year AY 2001-02, even by the ITAT, there was no reason to resort to surmises and conjectures to reject the assessee's books of account for the AY in question. Paragraph. The decision of this court in Ramchandra Ramnivas versus State of Orissa, 1970, 25 STC 501 bracket ORI bracket supports the aforementioned contention of the SSC. Full stop. There it was held that earning low profits by itself without a combination of other factors cannot be a ground for holding that the books of account are not properly maintained. Full stop. In Mohammad Umar versus Commissioner of Income Tax, 1975, 101 ITR 525 bracket Patna, the division bench of that High Court accepted the SSC's books of accounts and held that the rejection was based on suspicion and surmises as well as irrelevant material. Paragraph. In St. Teresa's Oil Mills was state of Kerala. A division bench of the you say 1970, 76 ITR 365 bracket Kerala, comma, a division bench of the Kerala High Court. Held that the rejection of accounts was not justified, particularly because it was based only on a variation of consumption of electricity. Full stop. In the present case, the mere non-issuance of the sale memos could not have been a ground to, production of sale memos could not have been a ground to reject the entire books of accounts, particularly since these were pertaining to sale of country liquor to tribal populations. Also, the ITAT appears to have overlooked the fact that the books of accounts were not rejected, of the SSC were not rejected by the Excise Department, and that the ITAT itself had accepted them for the subsequent AY 2001-02. For all of the aforementioned reasons, the two questions formulated by this court are answered in favor of the SSC and against the department. The impugned orders of the AO, the CITA, and the ITAT accordingly are set aside. The appeals are allowed, but in circumstances with no orders to cause.
Obliged.
Item number 7.
My lord, in item number 7, I am for the petitioner, my lord.
Yes.
My lord, in this case, the opposite party number 2 and 3 filed counter, my lord. But
That's okay. Now counter is order, no point. It's a 2005 writ petition. What is it about, sir? Tell us.
My lord, in this case, I am challenging the order of Annexure 1, my lord. But the petitioner is a Marfotdar of Jagannath Mahaprabhu property, my lord.
Right.
And in the year, in Annexure 1, they have passed order deleting the name of the petitioner, my lord. From his forefather, grandfather, he is doing Seva Puja as Marfotdar, my lord. That what is Annexure 2, hello? Hello?
No, we can hear you, sir. Carry on.
In Annexure 2, when the petitioner filed an application before the district magistrate, that order passed in favor of the petitioner, my lord, that he is the Marfotdar and he is doing Seva Puja in the temple, my lord. But recently, in Annexure, as per Annexure 1, they have removed the name of the petitioner. As per Annexure 1, my lord.
Sir, against the order of the sub-collector, can an appeal be filed?
No, it's in sub-collector, my lord.
Have you followed my question, sir?
Yes, my lord.
Yes, what is the answer?
My lord, the sub-collector has passed the order on the basis of the affidavit submitted by the petitioner himself. And your lordship may kindly see the impugned order at page 2.
Yes.
See, he has shown an affidavit stating that he had relinquished his right title interest over the aforesaid property of Jagannath Committee and further stated
my point, Mr. Monty, is it an appealable order?
Yes, that is applicable, but so far as this particular fact is concerned, he has acknowledged he is a government servant. He cannot act as the Marfotdar. He is not doing Seva Puja. That is why the sub-collector has conferred the status to the committee, who is actually doing the Seva Puja. And he has filed an affidavit before the concerned authority. And he is not relying upon that affidavit. That is the subject matter of the impugned order. Your lordship can see the impugned order. The sub-collector has relied upon the affidavit of the petitioner himself.
Correct. That he has no objection if it is recorded in the name of Jagannath Committee.
Now he is
No,
making a new
they have done this
No,
affidavit
how
by
can you say that
forcibly.
No. Please.
Yes, my lord. Already I have taken in that stand, my lord.
No. What is the date of the affidavit, sir?
They have filed in their counter, my lord.
No. You tell us the date of the affidavit.
Date of the affidavit, my lord. In 2003, my lord.
No. There must be a date, sir.
There is no complaint that forcefully. it
No,
was
no, that's what I'm
applied.
just trying to see what he did. When did he give the affidavit? When did he complain about forcibly being?
In 2025, 25/11/2003 month.
And when did you first tell them that you have taken this from me forcibly? When did you make such a complaint?
No, there is no such.
No, my lord, there is no
So
complaint.
we won't accept it now, sir. We won't accept your plea that the affidavit is taken from you forcibly. You say the challenge in the present petition is to an order passed by the sub-collector board on 27 January 2005 in RMA number 2/2005 bracket MIS bracket
One thing, my lord,
allowing the
as per the
plea of the Jagannath committee. What is the place? Rundi and Ashul.
Rundi Mahal.
Rundi Mahal. Okay.
Rundi Mahal.
In the district of Baudh.
In the district of Baudh. Paragraph. Counsel for the petitioner. This court has heard the submissions of Mr. So-and-so, Mr. Manta, learned counsel for the petitioner, and Mr. D.K. Manti, learned counsel for the state.
I'm appearing for the appeal part 2 and 3, my lord.
Page 2 of the, all right, sir, all right. Page 2 of the impugned order. It has been noted as under, take from the second para and continues page 8, running page 8, second paragraph, the whole of the second paragraph. Now the counsel for the petitioner seeks to contend that the aforementioned affidavit was taken under coercion. Full stop. The court is unable to accept this submission for the simple reason that, admittedly, the affidavit was given on, give us the date, sir, the date of the affidavit?
25/11/2003.
25th November 2003. And there was no letter written thereafter, soon thereafter, by the petitioner disowning the affidavit or claiming that it was taken from him under coercion, by subjecting him to coercion. Full stop. In fact, at no point in time was such a plea advanced by the petitioner prior to the filing of the present petition. Full stop. That plea, therefore, appears to be an afterthought. Paragraph, if indeed the petitioner did give an affidavit as noted in the impugned order, there is no reason why the sub-collector would not proceed to register the land in question in favor of the Jagannath committee of Rundi Mahal. Court is unable to find any error having been committed by the sub-collector in the impugned order. The writ petition is accordingly dismissed.
Item number 8.
May I please, your lordship? My lord, your lordship may permit me not to open my video because I'm not in proper dress. I've lost my mother. If your lordship permits, I can argue or I'll.
Yeah. You say Mr. Bose is in some personal difficulty today. The list.
My lord, I can argue the matter, but if your lordship may kindly allow me not to open my video, that much I pray, my lord.
Not necessary, sir. We'll keep it on 21st. All right.
Obliged, my lord. Obliged.
Item number 9.
I'm grateful, my lord.
Item number 9.
For item number 9, I'm really grateful to the Mr. Mahanti, additional government advocate. Actually, he telephoned me at 10 o'clock whether I am appearing in this case. I remember, my lord, Mr. M.R. Panda, senior advocate, was appearing. He has expired and he had requested me to do the case. But I couldn't actually trace the file or the brief right now. If your lordship give me 1 week time, I can get the file and argue the matter.
All right. At the request of Mr. S.P. Mustela, senior counsel appearing for the opposite party. List on 22nd February.
Obliged.
Item number 10. Item number 10.
None appears. Dismissed on all prosecution.
Item 11.
11, they are noting the petitioner is dead. One week time to file substitution.
Not in the year 2022, sir. When did he die?
My lord,
When did he die, sir?
I know the Mr. Mahanti is telephone me from the Mr. Bhupesh Mahanti.
So we'll have to tell us when did the petitioner die?
I have no idea. Mr. Mahanti tell me that it take time to file substitution petition, my lord.
Without this detail, we cannot simply adjourn it for that, sir.
On the Mr. Mahanti, my lord,
We'll pass it over. You find out from Mr. Mathi. Okay. Pass over.
Item number 12.
May it please your lordship. My lord, this file actually belonged to my associate, my lords. Unfortunately, he died in an accident, but I've just understood the bare fact of the case, my lords. There's a counter and my lords, writ application which is just handwritten, my lords, which is present before me. The main controversy is that, my lords, this present petitioner company is a 400 TP, my lords, iron ore company, my lords, and it had sought, it had challenged the act, it had purchased certain lands for its own expansion. Now, my lords, the government initiates land acquisition proceedings for acquiring some of those lands, not all the lands, which is in the schedule of this company for another factory, my lords, that is Adhunik Metallics is right now, my lords, in NCLT. Its net worth is minus 21% and it has become defunct. So, my lords, my friend can take, I've been trying to contact the client. Unfortunately, my lords, I'm not able to get the cause of action may not subsist anymore. I'll just find out, my lords, your lordship may keep it to next week, my lords. This is the only controversy, my lords.
All right. At the request of Mr. Kanungu,
My lords.
Senior Counsel to the Petitioner, list on 9th February.
Deeply obliged, my lords. Deeply obliged.
Item number 13.
Item 13 has become infructuous, my lord.
Counsel the petitioner states the petition has been rendered infructuous. It is disposed of.
Item number 14.
Your Honor, I am for the petitioner. Your Honor, this is an endowment matter. I am for the petitioner, Lord Jagannath Mahaprabhu. My lord, a miscase was filed 5263 for modification of order. Modification of order dated 23/4/2007. My lord, I have complied all the defect. I have removed it. So this miscase may be allowed first.
No, but you carry on with the matter, sir.
Yes,
carry
Your
on
Honor.
with the matter. You carry on with the matter.
Matter is an OEA case.
Yes.
This is an OEA case. The
Yes.
Tahsildar Puri have allowed my OEA, but subsequently they rejected my OEA and recorded the land in name of Lord Jagannath Mahaprabhu. I am Jagannath, Lord Jagannath Mahaprabhu Vijay Jagannath Vallabh Matha Puri. I am the Matha coming under the Endowment Act. So OEA collector decided my case as per Annexure 2, but subsequently recorded the land without giving me any intimation in favor of the Jagannath administration. This is the fact, my lord.
Who's for the other side?
My lord, I am appearing for the government, but opposite part number 4 is to appear on because the impugned order is in its favor. It is intercept fight between Jagannath Mahaprabhu versus Jagannath Mahaprabhu. That is, the land has been recorded in favor of
the temple itself.
Sri Mandira. The Jagannath
So,
temple.
how can you have an objection to the land being recorded in favor of?
They are
Sri
all
Mandir?
mathas under the Jagannath temple.
Correct. Correct.
So it is no private individual is recorded. It is
Correct.
recorded in the Jagannath Temple Trust. So
Yes.
these mathas are under the trust.
That's right. Sir, how can you possibly object? Mr.
Yes,
Binayak.
Your Honor. Yes, Your Honor. I am the main matha of the Jagannath temple.
But the temple itself having the land in its favor, how can you as a matter object? It's very absurd. It's very odd, sir.
Yes, Your Honor. I am in the entire year. I am serving to DT Lord Jagannath Mahaprabhu.
So what?
Yes.
So
now it is
all
recorded.
Jagannath Mahaprabhu come to my matha in the year 13 14 to 15
So whatever
occasions
it
on the
is,
year.
if the land is recorded in the name of the Lord, how can you object?
My lord, how I will maintain myself? I will maintain the motto myself, my lord.
This is not like, it's not the source of
No,
your
no,
income.
no.
Yeah, let us not go down that route.
That,
Yeah, the challenge in the present petition is to an order passed by the Tahsildar, Puri, under the Orissa Estate Abolition Act, in claim case number 2246 of 1774. The order dated 23rd October 1995 passed by the additional Tahsildar in OEA claim case number 2296 of 46 of 1974, as well as the order dated 31st August 1998 passed by the OEA collector cum Tahsildar Puri in OEA claim case number 144 of 1990, whereby the land in question has been recorded in favor of the Lord Jagannath Mahaprabhu. Paragraph. The petitioner happens to be the Marfat named as Jagannath Ballabh Endowment.
They are under administrative control of the Jagannath Temple Trust.
Which is under the administrative control of the Jagannath Temple Trust. Paragraph. The court fails to appreciate why the Temple Trust.
I am under control of Endowment Commissioner, my lord.
Or which is under the control of the Endowment Commissioner. The court fails to understand how the petitioner can possibly object to the land being recorded in the name of the Lord Jagannath Mahaprabhu, particularly since the trust functions only under the overall administrative control of the temple. Paragraph. The court therefore finds no merit in the writ petition and it is dismissed as such.
Item number 15. Item 15.
This was an opposition.
Item number
I am
16.
appealing for the department, my lord.
Item 16.
This is the assessment year 98-99, and this honorable court on 7/5/2007 has framed the question that para 7 of page 9 of my petition will be considered as a question of law. That is para 7 of page 9 of my brief, whether the ITAT is legally correct in holding that the addition of 29,53,544 is justified with such addition when such addition has been made on the consideration of materials partly relevant and partly irrelevant, and is also based on suspicion, conjecture, and surmises, having no nexus with the facts and materials on record, and whether such a finding of the ITAT is not contrary to the law laid down by the Honorable Supreme Court in 37 ITR, page 151, and 26 ITR, page 736. Well, the facts are like this. For previous year 97-98, the petitioner who is engaged in producing daily newspaper, that is Samaya, purchased paper worth of rupees 2 crore 16 lakhs. Well, out of 2 crore 16 lakhs, check by way of check payment, measure of the amount was paid, but the assessing officer refused and added the entire purchase made from one universal paper agency to be bogus, and added that income at my hand. Against that order, my lords, I went to the first appellate authority, and the first appellate authority, lords will kindly see, that is annexed to relevant page, and draw lords kind attention to page 49, para 10.4, it starts considering the factual position, the findings, observation of the additional CID communicated to the appellant, the latter dated 15/5/2001, it has to be held that the disallowance of rupees 2,16,73,543 cannot be disallowed. There was an opening balance of rupees 50,88,305 at the beginning of the year, to which the bills raised on different dates amounting to rupees 2 crore 16
So here has the question of law been framed? I don't think so.
ballots.
Here, I don't think the formal admission of the appeal has happened. I don't find any order framing any question of law.
That 7/5/2007 order is there, my lords, with me. And there they say that we admit the appeal on the grounds mentioned at page 7 of page 9.
Okay. So we have to read that as part of this. Right. No problem. No problem. So this is about addition of 29,53,500.
Yes, yes. This is the my lords, so far as the genuineness of the seller and purchaser are not disputed. The learned CIT appeal, he has allowed the balance amount that is out of 2 crore 16 lakh, 69 lakhs, some odd, 29 lakhs 53,544 mallards, he has disallowed it. Whereas when the genuineness and the transactions are not disbelieved, only because I have paid this amount by cash, he has disallowed it. And
Then
against
the next question is addition of 2 lakhs.
And that I am not pressing it, man.
All right. You say admit the following question of law is framed for consideration. Who's for the department?
Yes, Lord, I am appealing.
Yes, sir.
All right. Take from 7(1), page 9. Paragraph: the present appeal arises from an order dated 15 June 2001 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, (IT80). Order dated 28 May 2004 passed by the IT80, Cuttack Bench, Cuttack, and ITA number 440/CTK 2001. Paragraph: the question being short, it requires to be, the facts required to be only briefly discussed.
CIT appeal has also
For the AY assessment year (AY) in question, that is 1998-99, the appellant SSC filed its return of income, disclosing a net loss of rupees 843,862. Paragraph: the scrutiny was picked up for assessment, and the assessing officer (AO), while examining the list of sundry creditors, came across an outstanding liability of rupees 1.33 crores in the account of one Messrs. Universal Paper Enterprises, Naya Sadak, Cuttack. Paragraph: a purchase of newsprint had been shown from the said entity to the tune of rupees 216,73,543. Paragraph: of the above expenditure, the AO disallowed a sum of rupees 29,53,544 and granted relief only to the extent of 187,19,999. Paragraph: Mr. Rai, Learned Counsel, the SSC, points out how the withholding of the above amount was based entirely on surmises and conjectures, not based on the books of account produced before the AO. The only reason for disallowing the amount was that the amount is paid in cash. Full stop. Nevertheless, it did not impinge on the genuineness of the transaction. Paragraph. The SSE appears to have placed all the relevant details, including the exact quantity of newsprint requiring a daily circulation of 85,000 newspapers. Full stop. It appears to the court that whenever there is a disallowance of a substantial sum, in this case rupees 29,53,544, it had to be based on credible material, credible and relevant material. Full stop. On the other hand, it appears from the perusal of the impugned orders that the above addition was based only on suspicion and surmises and has no support in the records of the case. Paragraph. The question formulated by the court is therefore answered in the negative, that is in favor of the SSC and against the revenue. It is held that the ITAT erred in withholding the sum of rupees 29,53,544, particularly since it was based entirely on surmises and conjectures. Stop. The impugned order of the ITAT is accordingly set aside. The appeal is allowed, but in the circumstances, no orders to cause.
Item 17.
Rasif, only the
Item 17.
17, the ITA number 132 2005 is below the taxable limit.
17 is 43 of 2005, sir.
17 is different. my lord.
Sorry,
Item 16.
Sorry.
Item 17.
17, none appears.
17, my lord, I am appearing for the department, my lord. Yes, yes.
All right. Just put his name for the department.
Item number 18.
None appears. Dismissed for non-prosecution. This is all department's appeal, sir.
Yes, it is below the limit.
Oh, 18, 19, 19 also.
No. 19, 134 2005. That file is not with me. I don't have any.
All right. 18, you say, Mr. Satpathy informs the court that the tax effect is below the monetary limit. The appeal is accordingly dismissed.
And ITA number 130 and ITA number 136 2005.
136?
Item 19 tag. Yes, 136 2000. It is also below the limit.
All right. 136 also you say tax effect is stated to be below the monetary limit. The appeal is accordingly disposed of.
139.
139, my lord, I am appealing.
17 because I don't.
Item 20, item 20, my lord, item number 139.
Mr. Mahabada, just a minute.
Who is appearing 134, sir?
134, I am appearing.
No, you are appearing only 136, you said.
No. 134, I am appearing.
Okay, who's in 136?
136, I have no file. Therefore, I am requesting you to kindly fix it and 7th. Because file is not available. I am also assured that it may within the limit, but I don't have file.
It's okay. We'll dispose it off. If you can file an IA if it is wrong.
Yes.
Same order in 136. All right. 139.
139, my lord, I am appearing. That is below the tax.
Same order in 139. Who's in 145?
145, I am appearing, my lord.
What's the tax limit?
That is below tax limit.
All right. Again, same order in 21.
20 and 21, my lord, my appearance be noted.
All right.
Item 22.
My lord, I have no instruction. When I joined a judicial member of SESTAT, the file has been taken away by the clients.
All right.
In 2006.
Counsel of the appellant states that he has no instructions. Dismissed, non-prosecution.
Item 23. Item number 23.
22, I am appearing. 22.
You're for the department, no, sir?
Yes.
So same order. Just put his name.
Item 23.
None appears for the petitioner. Dismissed from non-prosecution.
Item 24.
Item 24, my lord, Mr. Sarada Sadangi is in the last 3 days in COVID.
All right. Counsel, the petitioner is stated to be unwell. List on 24th February.
Item 25.
Item 25. Item could be I am for the opposite party temple administration, my lord.
I'm for instruction to appear on behalf of the petitioner. The brief was with Honorable Justice Mr. Mahapatra before his elevation, my lord. I need a week's time for taking instruction with the client. I was unable to contact him.
All right. At the request of who's this?
My lord, Mr. L.K. Maharana, my lord. L.K. Maharana.
At the request of Mr. L.K. Maharana, counsel appearing on behalf of the petitioner, list on 25th February.
Obliged, my lord.
Item 26.
26, my lord, there is no instruction, my lord.
Counsel, petitioner states there are no instructions.
Item 27.
Your lordship, in item number 27, no instruction, your lordship.
Same in 27.
Liberty may be granted, my lord.
No question of liberty. Yes.
Item 28.
None appears. Dismissed for non-prosecution.
Item 29.
29, I am appearing. Here is a case. The question is whether the 80 CCH4 is permissible deduction may be allowed in favor of the petitioner, favor of the assessee. Kindly see the tribunal order.
What's the tax effect here?
Tax effect 5 lakhs 21 as it's appear from the tribunal page 12.
So 5 lakhs means it's below the monetary limit.
Yes, but
counsel for the appellant, the tax effect being below the monetary limit, the appeal is disposed of. All right.
Item 30.
My lord, may I kindly record my name for this response.
Item number 30, my lord, on behalf of Mr. J. M. Patnaik. Item number 30, my lord. On behalf of Mr. J. M. Patnaik, this question has already been settled under the Vivasa Vishwas scheme. So the matter may be permitted to withdraw.
Counsel for the appellant seeks leave to withdraw this appeal.
Item 31.
Service withdrawn. Right.
Item 31.
None appears for the appellant. Dismissed.
No, my lords. Item 31. Am I audible, my lords?
Yes.
My lords, item 31, this is an appeal filed in the year 2006. And the claim under 115 JA24, Roman 4, as well as the liability on account of medical reimbursement and computed actual variation basis has been disallowed, and the same has been upheld by the first appellate authority as well as by the ITAT authority. The substantial
question. The present appeal has not been admitted. No question has been yet been framed.
No, not yet been admitted.
Yes, my lords. Yes, my lords.
How many questions you formulated? Some 8 questions. What is all this? Same thing again and again.
My lords, my lord, may come to page 12, paragraph 29.
That's what you formulated, some 8 questions, sir.
My lords.
I think only the first question is relevant.
First and second, when the claim relating to leave encashment and post-retirement medical benefits.
Last question is relevant. That's a kindly see V.
First Roman 1 and Roman 1:4 IV.
Yes.
My lords, the facts of the case is that the power generated by NALCO, for both use for its CPP in alumina production as well as selling the same to Gridco. Now the question is, NALCO claimed rupees 45.48 crores as a deduction under 115 JA24, which states, my lords, it may say JA24. the amount of profits derived by an industrial undertaking from the business of generation or generation and distribution of power. That is, the assessing officer erroneously come to a finding that it is being used by NALCO, so it is not coming under 115(2)(j) Roman 4, and they have disallowed my claim, and the same was affirmed by the First Appellate Authority CIT in its order under Annexure 2. Relevant page is relevant portion. Let me come to page 63, paragraph 22.
No, 1 minute. You were reading 115J824.
My lords.
The amount of
Deemed income relating to certain companies.
Yes.
115JA. Every assessee being a company shall, for the purpose of this section, prepare its profits and loss account for the relevant previous year in accordance with the provisions such and such and such. My lord, may come to Roman 4.
Yes.
The amount of profits derived by an industrial undertaking from the business of generation or generation and distribution of power. So it is the computation of profit from the CPP is the question. But they have said, the assessing officer has specifically said, since the power utilized, I am producing, the production of the power is utilized by myself only, therefore I am not entitled to the deduction under 115(2)(j) Roman 4.
Yes.
And the liability, and the second, that is Roman 4, the substantial question, the liability of 441.7 with regard to leave encashment and retirement benefits has been completely disallowed, saying that it is a contingent liability. Whereas the decision of the Honorable Supreme Court, that is also I have quoted, I have stated.
Who's for the department here?
Yes, I am appearing.
What do you say?
Admit and give me some time, I will reply.
Sorry?
If your lordship admitted, then give me some time to reply. I am not actually, file is today morning I received the file, so
all right.
Admit
the following questions of law framed for determination. Take 29, 1 and 4 from page 12. Mr. Satpathy needs some time to get ready with the arguments. At his request, list on 7th March.
Item 32.
32, my lords. Here the interpretation of 35DDA relating to the amount paid and the liability incurred. That is what the precise question of law. That we have claimed, the appellant has claimed rupees 12 crore 83 lakhs 51,995 on account of voluntary retirement scheme, that is friendly departure scheme. Now, out of those 12 crore 83 51,995, the amount actually paid to the employees is 86 lakhs 10,926. But fact remains, the liability incurred is 12 crore 83 lakhs. Now, the assessing officer has...
You have gone on accrual basis.
Yes, that is what 35DDA. My lord, the definition under 28, section 28 to 41 clearly states amount paid and incurred.
Right. So, Mr. Satpathy, here again, it has not been admitted.
It is admitted. It is admitted.
Mahapatra is appearing in this case.
It is admitted on, as far as my record shows, on 12/9/2007.
Correct. And substantial question of law has been framed. Correct.
My lords.
Yes, Mr. Satpathy, what do you say here?
Mr. Mahapatra.
I am appearing.
Mr. Mahapatra, yes.
My lord, in this case, lordship kindly have a glance to page 31.
Yes.
Of the paper book, my lord.
Yes.
Where the provision has been 33, my lord, that has been quoted. 35 DDA, that is my lord, the actual paid, the actual amount paid, my lord, that has been, I have carefully analyzed the rival contraventions, the provisions on section page 31, paragraph 15, your lordship, I see. The provisions of 35 DDA come into statute with effect from 1/4/2001, the assessment year 2001 and 2, with respect to amortization of the expenditure incurred on our VRS, according to which 1/5 of the expenditure incurred in every previous year by the way of payment of any sum to an employee at the voluntary retirement in accordance with the scheme of retirement will be allowed as the deduction, and the balance will be allowed in equal installments for each of the 4 immediately succeeding previous years. According to the statutory provision, the following parameters must have been satisfied. The assessee must incur any expenditure in previous year by way of payment of any sum in respect of VRS.
No. So incurring a liability is different from actually paying the entire sum.
Yes, my lord. That liability is there, but my lord, that has been paid. The amount which has already been paid, my lord, that has been excluded. That has been allowed.
No.
In this case, the next paragraph, lordship, you can see. In this case, appellant company formulated the VRS FDS scheme. In this case, as per the circular issued by the appellant company on 31st July 2020, this scheme provides monthly pension to those separating employees till the age of 60 years or a period of 10 years, whichever is less. The employees opting for such scheme were to be intimated the company with the specific date and were entitled to the benefit subject to its acceptance by the employer. As noted by the AO, his assessment in his assessment order, although the FDS liability in respect
The
of
voluntary retirement scheme expenditure, how can it be treated as capital expenditure? I never understood this. The whole reasoning in para 15 is that this is capital expenditure and not revenue expenditure. How do you get that? This is by no means a capital expenditure, sir. Payment made under the voluntary retirement scheme cannot be a capital expenditure. That's the reasoning in para 15.
Yes, ma'am. That has been accepted by the.
No, that's erroneous, sir. That's clearly erroneous. You see, this appeal arises from an order dated 28 November 2005, passed the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in ITA number 791/CTK/2004 for the assessment year, bracket AY 2001-02. While admitting this appeal on 12th September 2007, the following question of law was framed for consideration. 20 Roman 1. The background facts are that the appellant SSC is stated to be engaged in the manufacture and sale of refractory products. So the appellant follows the mercantile system of accounting, and its accounts are maintained on the accrual system of accounting. Paragraph. For the AY 2001-02, bracket, accounting year 2000-01, bracket, the appellant implemented a voluntary retirement scheme, bracket VRS, brackets, for its employees, which is otherwise known as the Friendly Departure Scheme, bracket FDS. Stop. 291 employees were separated during the accounting year 2000-01 in terms of the said FDS. Stop. The appellant points out that the liability towards compensation under the FTS in respect of the said 291 employees, worked out to rupees 12,83,51,995. This ascertained liability was accrued during the accounting year 2000-01 and accordingly was accounted for in the SSC's books of accounts for the said AY. The aforementioned sum was amortized over a period of 60 months, starting from the accounting year 2000-01. And this was reflected in the balance sheet as of 31st March 2001. Paragraph. The relevant provision is section 35DD capital A bracket 1 of the Act, which read as under. Take from para 8, page 9 of the paper book. Paragraph. Under section 43 bracket 2 of the IT Act, the word single quotes paid means single quotes actually paid or incurred according to the method of accounting upon the basis of which the profits or gains are computed under the head profits and gains of business or profession, unquote. In other words, the above definition does not require actual payment, even if the liability is full stop, even if the liability is incurred and the SSC is following the accrual system of accounting command. The liability would stand attracted in the first year of it being incurred, and it would be up to the SSC to amortize it by spreading it over the remaining years. Full stop. However, the assessing officer bracket AO, that is the Assistant Commissioner of Income Tax Circle 1 bracket 1 Sambalpur, disallowed the claim of deduction of rupees 256,7399 and only allowed 1/5 of the amount, that is 17,22,059. The balance amount was treated as single quotes contingent liability, unquote, which had not been ascertained or quantified and could not be treated as expenditure. Full stop. The above order was affirmed by the Commissioner of Income Tax Appeals bracket CITA. Holding the amortization of the expenditure of the accrued liability to be a capital expenditure, unquote. When the appellant SSC further went before the ITAT, it concurred with the view of the CITA that only the amount paid during the year had to be taken into consideration and not the entire amount payable under the VRS during the year. Paragraph. Having heard learned counsel of the parties, the court is of the view that the ITAT erred in treating the liability not as an accrued one, liability under the VRS scheme not as an accrued one, and in proceeding on the basis that only the amount actually paid during the AY in question can be allowed. Full stop. The very definition of single quotes paid under section 43 bracket 2 of the IT Act contemplates the SSC single quotes incurring, unquote, the liability. Full stop. There is no dispute that the appellant follows the accrual method of accounting So there's also no dispute on the actual amount that was incurred as liability by the SSC under the VRS scheme. So in the circumstances, it was erroneous on the part of the CITA as well as the ITAT to treat the expenditure towards the aforementioned liability as a single quotes capital expenditure, unquote. There was no warrant for such a conclusion, particularly since the SSC follows the mercantile system of accounting and not the cash system, and that its income is assessed under the head single quotes profits and gains of business or profession, unquote. For the aforementioned reasons, the question framed by the court is answered in favor of the SSC and against the department by holding that the allowance for the deduction of the VRS has to be based on the entire liability incurred and not just on the amount paid during the relevant AY. The impugned orders of the AO, the CITA, and the ITAT are set aside to the above extent. The appeal is allowed, but with no orders to cause.
Item 33. Item number 33.
None appears for the appellant. Dismiss for non-prosecution.
I am appearing this case.
Item number 34. Item 34.
37. Who is appearing in 34? The department's appeal.
Mr. Mahapatra is appearing.
34. 34, my lord. File is not available. We'll verify, my lord. Can allow some time.
Is a question of law being framed. Even the question has not been framed so far. You don't have the paper book?
My lord, I or my lord senior Mr. Satpathy have no paper book or record, my lord. We will ascertain from the department. Kindly allow us.
All right. Mr. Mahapatra states that he does not have the paper book at his request list on 23rd February.
Item number 35.
May I please, my lord?
Yes.
My lord, in this case, the appellant happens to be a private limited company which has been held as an assessed in default under section 201 of the IT Act 1961 for non-deduction of TDS under section 192 from the director's remuneration, for which he has been held liable under section 201 for the amount of short deduction, if any, he has to pay under section 201, and then 201 capital A, the amount of interest, that means the amount of short deduction till it is payment, the interest calculation he has to pay. Thereafter, a penalty is also imposed under section 271 capital C. Now, the 201 has that is the equal the amount of short deduction has been deleted by the CIT, holding that there is no short deduction. Even the 2011A, that is the interest amount, has been also deleted by ITAT, holding that there is no short deduction, that cannot be imposition of any interest. But the penalty has been imposed, even though the quantum has been already deleted. And in fact, there are two companies, my lord, in this case, where there are 5 common directors. There are, and the DDO, the drawing and disbursing officer, the managing director of both the companies are same. And all 5 are drawing, that is remuneration from both the companies. And what happened in this case is, the first, as the DDO is same, he calculated the total remuneration from both the companies. And then he started deducting TDS according to his wishes, which is not at par. Means the first company, if there is a deduction has to be made of 10 rupees, he deducted suppose 7. The other company, maybe the deduction is 6 rupees, he deducted 13. So if you take combination of both the salaries, as it has to be done, because individually when the return has to be filed by the individual assessees, all the directors, they have to take into consideration of both the salaries and the DDS deducted from both the companies. The assessing of the officer surprisingly is the same for all the 5 directors and also the companies. But what the assessing authority did, he took into consideration both the salaries from both the companies, but said there is a short deduction, taking into consideration TDS deducted from individual company, and fashioned the liability under section 201 and 201A, and then imposed a penalty under section 271 capital C. And the 201 order and 201A order has been already passed. There is no liability towards any short deduction of tax under section 201. Or
where do you get that? Where do you get that 201(1)A order has been quashed? Where is that?
I have annexed the CIT appeals order in this case, where it has been clearly stated by the CIT appeal. Let me take you, Your Honor, to that CIT appeals order. 16 to 24, 16 to 24. Yeah. The CIT appeal has held that there is no short deduction of TDS.
Where is that? Which paragraph?
Yes, Your Honor. Just a minute.
That's at page 22, sir.
Yes.
Page 22.
Yes, Your Honor. Yes.
All right. Yes, who's for the department?
Hello, I am not.
What do you say? This whole original liability itself is deleted under 201(1). Where's the question of penalty? Where's the question of penalty?
Yes, ma'am, that has been deleted. But
then it's meaningless, sir, having penalty once the main liability is deleted.
Yes, yes.
All right. The present appeal arises from an order dated 29 August 2006 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in ITA numbers 107 and 108/CTK/2006 for the assessment year, bracket AY 2003-04. Paragraph. By the said impugned order, the IT80 dismissed the appeals filed by the appellant SSC against an order dated 23rd January 2006 passed by the Commissioner of Income Tax, bracket appeals -1, bracket CIT, bracket A, Bhubaneswar, dismissing the SSC's appeals, affirming the penalty orders passed by the assessing officer, bracket AO. Paragraph. The appellant is the managing director of Bharat Motors Limited, bracket BML, bracket, and has been held to be an appellant in default, has been deemed as the appellant in default for non-deduction of tax deducted at source, bracket TDS, in terms of section 201, bracket 1 of the Income Tax Act 1961, bracket IT Act. So accordingly, the AO levied a penalty of rupees 652,675 on the appellant under section 371 capital C of the IT Act on the ground that there was an alleged short deduction of TDS which was in contravention of Section 192 of the Act. Paragraph, while admitting this appeal on 21st September 2007, the following questions of law were framed for consideration. Take para 13, 2, 3, and 6. Para 13, 2, 3, and 6. Paragraph. It is seen from the order of the CITA
Page 6, para 4, state appeals order, which is available at page 21, running page 21.
Yes. That in para 4.1, it was specifically concluded by the CITA that, open quotation, the demand of rupees 652,675 raised by treating the SSC appellant as SSC in default, U/S 201(1), to the extent of short deduction is hereby deleted, unquote. The reasoning for this was that the employees had paid their tax liability directly through the self-assessment and had filed the returns of income. So therefore, no further tax is payable. Full stop. Paragraph. Once it has been categorically held by the CIT bracket A that there was no short deduction of TDS, and that therefore the SSC could not be deemed to be an SSC in default for the purpose of Section 201 bracket 1A 1 bracket 1 of the IT Act, there is no question of proceeding to impose a penalty under Section 271 capital C of the Act. Counsel for the department has been unable to point out how the above orders of the CITA and the ITAT upholding the penalty levied on the appellant SSC could be justified. Consequently, the questions framed by this court are all answered in favor of the SSC and against the department by holding that the ITAT was not justified in dismissing the appellant's appeal, and that there is no question of sustaining the penalty imposed on the appellant once it was held that there was no short deduction of the TDS. Stop. It is again held that there was no occasion for the department to have applied Section 271 capital C to levy a penalty on the appellant. Full stop. The impugned orders of the ITAT and the corresponding orders of the AO and CIT bracket A to the above extent are hereby set aside. The appeal is allowed, but in the circumstances, no orders is to pass.
May I please, my lord? My lord, in fact, there was two companies, Sri Bharat Motor, and there was a common order passed by the CIT and the ITAT. There are two appeals filed before the Honorable High Court, which is 131, 2006, 132, 2006. Now, 132, 2006 has been taken up today, but unfortunately, 131 has been dismissed because there was a bonds list given by the department, and there was a department circular regarding monetary limit. So without considering, it's a assessor's appeal, but without considering that, they have dismissed that appeal because on the ground of monetary limit with a rider to restore it subsequently. It has been dismissed, I think, 2018 or 19, which we could not come to know when it came up. When I checked the record, I found out I also filed a CMPL for restoration of that appeal. Same order will be passed there because this is a consequential order, both the cases. They have taken salary of both cases.
In the beginning, you say as regards 132 of 2006. Appeal direct. So where is the CMAPL?
CMPL 10 2022, I have filed it. It's not taken.
So when it comes up, you tell us.
Obliged.
Item 36. Item number 36.
None appears. Dismissed for non-prosecution.
Item 37.
Your Lordship, item 36, the file is misplaced, Your Lordship. Item 36.
Yes.
So kindly taken up 2 weeks after.
No. This is a 2007 matter, sir. Don't be so casual. We'll pass it over. You find out your file.
Lordship.
We'll pass it over. You find out your file. Yes.
Item 37. Item number 37.
None appears. Dismissed for non-prosecution.
Item 38.
May I please, Your Lordship? My Lord, the present date application has been filed challenging the judgment dated 22nd December 2006, passed by the opposite party number 2, which is at page 38, my Lord. Annex 5, page 38.
Yes.
My Lord, this appeal was preferred against the order passed by the opposite party number 1 and a suo motu proceeding initiated under the provisions of Orissa scheduled areas transfer of immovable property by scheduled tribes regulations in 1956. My Lord, so far as before going to the merits of the case, my Lord, I humbly submit that the entire proceeding is illegal because the object of the regulation is to, my Lord, the control and check transfer of immovable property by scheduled tribes. Your Lordship, I draw my Lord's attention to the definition of a transfer of immovable property, my Lord. My Lord, that is 2A defines transfer of immovable property. Transfer of immovable property means mortgage with or without possession, lease, sale, give, exchange, or any other dealings with such property not being a testamentary disposition and includes a charge or contract relating to such property. My Lord, in this case, my Lord, admittedly, the disputed land over which the petition church has been constructed, that originally belongs to one late Joseph Pradhan, my Lord. He is admittedly a Christian by religion and a scheduled tribe. He was a bachelor. He constructed a church over the said property, and in order to facilitate worship by the Christian community, Archbishop appointed late Joseph Pradhan as the priest of the church. And after his death, my Lord, the Archbishop appointed priest from time to time, and the church, so far as the church is concerned, over which the property over which the church has been constructed, there is no such transfer as per the definition of a transfer of immovable property, my Lord.
No. In whose name does the property stand?
That is, my Lord, one Joseph Pradhan.
The name of the scheduled tribe. He is a scheduled tribe.
Yes, my Lord.
So then where is the transfer then, Mr. Mohanty?
My Lord, not only transfer give, but also part with possession. That is what my learned friend has read. The last portion, I request him to again read that last portion. It is coming because he has parted with possession. this
No, he has
petitioner
not
is in
parted with it. See, the difficulty is he constructed a church. He did not part with possession.
no, without what I find
Just
from the
imagine
impugned
if on your
order-
own land, no, if on your own land you constructed a temple, all right, and you engage some priests to conduct puja. Have you parted possession of the land to the priests? No. They're only
But that
performing
is-
a service.
no evidence is produced by them before the lower authorities that for this purpose he has parted with the possession of the land in
No,
favor of
there's
the
no
church.
parting with possession, sir. This is what I'm trying to say. If he's building a church on his own land, where is the question of parting with possession?
That is also not proved by the petitioner that he has
No, it's the other
constructed
way
this.
around. You are alleging that he has parted possession. You have to prove it.
My lord, may kindly see the page 3 of the impugned order. In this regard, reference was also made to the judgment of Honorable Supreme Court reported in so and so by learned GP, wherein Honorable Supreme Court held any transaction or dealing with immovable property which would have the effect of extinguishing the title, possession, or right to possess such property in a tribal and vesting the same for non-tribal could be included within the meaning
Where
of
is
the
that? Where is that, sir? It's simply a quoting of a judgment. Where are these elements present here?
that this is effect of extinguishing the possession of the
Where
property
is
of the
it, sir?
tribal.
Who said his possession is extinguished? Nobody said that.
Because he is not the recorded owner. The person is in possession, he is not the recorded owner. Recorded
No,
owner.
that is different, sir. 1 minute. There's no person in possession once there's a church.
Yes, my lord.
Then the church is not an entity in whose name the record of rights there's any mutation.
Yes, it could be
the
because
record
church
still shows this Pradhan to be the owner.
Yeah. Yes, my lord.
Then and there is
That
no
is the
separate
finding.
recording. No, there's no separate recording of building.
That is the finding of the learned court below. The learned court below has held that this is also coming under the definition of transfer of immovable property because the possession has been given to a person who is non-tribal.
No, where is this person? That's what I'm not able to understand. Roman Catholic.
That person
Church.
is the priest who is in possession. Possession of the.
Just see the cost title itself. It simply says Roman Catholic Church, not the priest.
Lordship may pass necessary orders.
All right. So we'll allow the writ petition, will pass the detailed order.
Yes, ma'am.
All right.
Okay.
Item 39.
Pardon me, I am in 37. My lordship. I am for the petition item number 37. Sorry, because of some connection problem, my voice could not be reached there.
Right. Tell us what the matter is about.
This is I have challenged the Annexer 5, that is the order of industrial tribunal that is relating to promotion. This issue, my lordship, with regard to permission of promotion, that is year back in 1992. In the meantime, even at the time of passing the hours, there were 3 promotions have been already there. In the meantime, also I find that some of the there are 10.
Nothing has happened.
Yes,
Mr. Sahu, you are Mr. Naresh Chandra Sahu, correct?
Yes, my lord.
There has been no stay of the impugned award. Correct?
Yes, there is no stay.
And you did not implement it.
That instruction I don't have.
No, you don't have to have instruction. If you had implemented, you would have instructed you. They've not implemented it. So they've not instructed you.
My lordship may call this matter next week.
No question, sir. This is what happens. We go on calling because council is never ready with instructions. Matters never end because never is council ready with instruction. We can't go on adjourning like this, sir. Sorry.
My lordship, because in the
you
meantime,
take advantage of the fact that the workmen are not going to seek enforcement. And you don't get a stay from here. Nothing happens.
There is no stay, that's my lord.
So nothing has happened. The last 17 years, nothing has happened, sir. It's very unfortunate.
My lordship may dispose of.
Yes. You say the challenge in the present petition by the management is to an award dated 10th May 2006 of the Central Government Industrial Tribunal, come Labour Court, Bhubaneswar, bracket Tribunal, in Industrial Dispute Case number 264 of 2001. By the impugned award, the tribunal directed the petitioner management to give notional promotion to the EP Category 1 Mazdoors pursuant to the implementation instruction number 49 generated from out of the National Coal Wage Agreement -4 paragraph. Although the impugned award is dated 10th May 2006, the present petition was filed only on 14th February 2007, and for a period of 7 years thereafter, it was not even listed. So till date, not a single effective order has been passed in the matter. No notice has been issued. There has been no order staying the operation of the impugned award. Counsel of the petitioner does not even have instructions on whether the impugned award has been implemented by the petitioner. Paragraph. In the circumstances, the court sees no reason why it should, more than 15 years after the passing of the award, interfere with it when it has not been stayed during all these years. Interfering at this stage would only cause irreversible hardship to the opposite party workmen. When at full stop, the court accordingly dismisses the writ petition.
Item 39. Item number 39.
None appears for the petition. Dismissed not possible.
Item number 40.
40, my lords, I am appearing. My lords, this is filed against the impugned award dated 6/2/2007 of the learned Labour Court. My lords, directed for reinstatement with back wages. And my lords, the workmen, as per our ground, my lords, we have averred in our written statement also annexed documents. Lords, the workman was engaged during the period from 1988 to 91 under the erstwhile OACB. At that time also Vesco was not in the picture, and also Gridco did not come at that time. During such time he was he was not allowed during 1991 since then, and he only worked for a period of 53 days. Thereafter, my lords, he did not also pursue the matter, and after a long lapse of 11 years in the year 2002, the dispute was referred. And in addition to that, again after a delay of 3 years, that is around 2005, he filed the claim petition, my lords, after a long lapse of delay without any satisfactory explanation also regarding that. And my lords, we have also stated in our written statement, that is at page 42, my lords may refer. Gridco also, with effect from 28/5/96, issued total ban of engagement of NMR during that time. So, because of that, also Vesco cannot reinstate the workmen and cannot allow, since my lords, Vesco does not employ the NMRs on daily rated workers departmentally, and the recruitment of regular
What happened to 17B? Have you complied with all the 17B
that has been
orders?
complied, my lords, and he has been getting also wages
Who's for the
of
workmen?
the interim order.
Anyway, who's for the workmen? Who's for the workmen, sir?
My lord, workmen.
Mr. Kanungo. There was a Mr. Kanungo who had appeared.
My senior counsel, Mr. Kanungo, has appeared, my lord. So,
That's right. Is he here today?
My lords, I am not sure, my lords.
How old will the workman be now?
My lords, around 55 years, my lords. Now, by the time. So he
Sir,
also.
in 2007, he was 40.
40, my lords.
Correct. He'll be 55 now. And
Around
what is your retirement age in Vesco?
My lords, Vesco, 60 years, my lords.
Okay.
He also won't be having any expertise now also for working in the electric.
No, but somebody should appear for him, right? We can't hear.
Yes, my lord. Yes, my lord. That is right. My lord. That is.
You say Mr. Kanungo, Mr. Milan Kanungo is shown to have been appearing for the workman. However, he is not present today when the matter is called up. The registry will inform Mr. Kanungo telephonically to remain present on the next date. List on 9th March.
Fresh admission, item number 41.
May I please, Your Lords?
Lord, the repetition was filed. Item 41.
This is a transfer of OA, my lord.
Transfer of
nothing,
OA,
nothing survives. All right. Same order.
Already, my lords? Yes.
Same order. Yes.
Already transferred.
Item 42.
May I please, Your Lords? Page 36, annexure 2 in the impugn order. My lord, this is regarding RSCB matters. In a number of cases, Your Lordship has already issued notice. And the
When
same
it
has
was
been
coming up? When
in
are those
March,
coming?
March 2nd week. Particular date has not been given. The 2nd week of March.
No, give us a connected matters.
I will give. 30-40 matters are there. I'll give, my lord.
All
One
right.
number I am giving, that 6244 2020 and a batch of cases.
All right. Notice list along with 6244 of 2020 and batch of cases.
Well,
right.
Item 43.
Matter, my lord. My lord, similar order has been passed by this honorable court by the annexure 3, my lord. Matter relating to challenging the illegal and arbitrary action of the opposite party not making any payment.
No. This is when was your contract executed, sir?
Executed, my lord. That is my lord.
When was the contract concluding date? When have you come?
Page 14, my lord. Date of agreement, my lord. 30/11/2017, my lord.
So this is, and when did you conclude the work?
29/8/2018.
So this is far beyond 6 months, sir. Under the circular, you should make your claims within 6 months.
My lord.
It's all time barred. You say the claims of the petitioner in these cases is time barred, and therefore the court cannot grant any relief. The petitions are accordingly dismissed.
Item 44.
My lord, out of 2 defects, my lord, 1 defect is already removed. For the other defect, my lord, I am praying for some time, my lord. Defect number C is already, a copy is served, my lord. Defect number 11, your lordship, I seek some time.
My lord, time may be granted to remove the defect, my lord. Time may be granted to remove the defect, my lord.
My lord, I am audible, your lordship.
Item 44.
44. We are in 44, sir, now.
My lord, I am in 44, my lord. Out of 2 defects, my
Counsel
lord,
for
1
the
defect.
petitioner states that defect should be cured within 1 week. This thereafter.
Item 45.
May I please, your lordship. Item 45, your lordship.
Yes.
May I please, your lordship. Your lordship, similar items you posted to 10/2/2022, your lordship. Your lordship,
list on 10/2/22. Just see list on
in
20.
item 45, your lordship may see
number
annexure
39/206 of 202.
Item 45, your lordship may see this year the application has been filed after that cut-off date. The application is doubtful, my lord. Your lordship for a moment see page 17.
Yes, this is a case law.
Your lordship may see page 16 is the Your Lordship may see page 16 is the notice. This is regarding a notice for revalidating NOC. My Lord, Your Lordship may see that there is a date. The last date is 15/1/2020. Lordship got it, my Lord.
Yes.
On or before 15/1/2020. Then, my Lord, Your Lordship see the next page. He has filed the application. It is stated that Your Lordship may see the above it has been written at 29/12/2020.
Yes.
Then, my Lord, Your Lordship may see, even if that application is 29/12, he has annexed a document that demand draft 21/21. How can it be? Filed application in 20 and annexed the demand draft of 2021.
Yes, Mr. Pradhan, what's happening here?
Your Lordship, prior to that, we have filed 5 applications, Your Lordship.
This is his application.
No, the postal receipt shows which date, Mr. Kuntia? There's a
My Lord,
postal
Your Lordship may
receipt
see,
there.
Your Lordship may see first date is
1st March. So he's sent all of this only on 1st March.
no,
Yes, the postal receipt says 1st March.
But the date is 29/12/2020, and he
I
had to
know.
apply.
So apparently he typed this letter on 29/12, took a draft in January and posted it in March.
He had to apply before 15/1/2020.
So
He had
your
to
time
apply.
barred. Your time
Yes,
barred.
that
Yes,
I'm
Mr.
saying.
Pradhan. Yes, Mr. Pradhan, what do you say?
Your Lordship, can you take up this matter tomorrow, Your Lordship?
No,
Mr.
no,
Pradhan
no.
will argue this matter. Can you take up this matter tomorrow, Your
No,
Lordship?
why should we take it
Passover,
up
Your Lordship.
tomorrow? Why should we
Passover,
take it
Your
up
Lordship.
tomorrow? Passover.
Some
Okay,
problem.
Passover.
Passover, Your Lordship.
Passover.
Item 46.
May I please, Your Lordship? May I please, Your Lordship?
Yes, please.
Your Lordship may see Annexure 3, page 44.
So this is heavily time barred, sir.
My admittedly time, but what has happened this matter earlier he has approved the learned tribunal. Tribunal has directed that I have annexed that order. The tribunal has directed to consider his case and to bring him to the workers establishment from the date when his juniors have been brought over. Accordingly, we have brought up Your Lordship may see that is the order, my lord.
No, then he filed a review petition.
No, my lord. We have brought him to the workers establishment from the date as per the direction of the tribunal. Your Lordship, page 45 is the order of the tribunal, first order.
Right.
We implemented that. That has been implemented, and we, Your Lordship, page 59. As for the direction of the learned tribunal, we have implemented that order and bringing him to the worker establishment with effect from the date when his junior have been brought over to the worker establishment with effect from 10/12/2008. Your Lordship, page 59. After that, he filed another original application seeking for regularization of his service from the date when his juniors have, claiming that his juniors have been regularized earlier. And the learned tribunal had directed to regularize. And our stand is that two Sudam Naiks are there. One is appointed prior to him and another is appointed after him. Who was appointed prior to him, he has been brought over to the regular establishment with effect from 97. So he cannot claim at parity with that Sudam Charan Naik. The tribunal directed to regularize, we filed the review annexing that order that has not been taken into account. But this is a case where Your Lordship has pointed out that is a case of barred by limitation.
Yes, yes. You say we leave the question of law open. It is seen that the challenge in the present petition is to two orders of the Orissa Administrative Tribunal. One is dated 17th July 2017 in OA number 21 of 2013, and the other is to an order dated 29 January 2019 in review petition number 12 of 2018. The present petition, however, was filed only on 30th November 2021. That is more than 4 years after the first mentioned order and nearly 3 years after the second mentioned order. There is no satisfactory explanation in the petition for the inordinate delay in filing these petitions, except in para 39, which reads as under. The above explanation being totally unsatisfactory and the period of delay being long prior to the onset of the COVID-19 pandemic, the court is not satisfied that any reasonable explanation has been offered for the inordinate delay. The petition is accordingly dismissed on the ground of laches. However, the question of law raised, any question of law, if any, arising from the impugned orders is left open for decision in an appropriate case. It is clarified that the impugned order will not constitute a precedent.
Right.
The petition is dismissed with the above observations.
Item 47.
47, that RSCP is similar to 42.
So what is that? This notice, then he list along with that.
Right.
What I pray, my lords, item 45.
It's passed over.
Item 45, my lord.
Yes.
Here, this is a case where my application for issuance of revalidated opposite party number 3.
Yes.
Here, my lords, despite several reminders, they have not issued my revalidated NOC. I mean, last reminder is Annexure 5.
Sir, that Annexure 5 is very curious, sir.
That, my lord, I have seen that. My lord, para 9 of my writ petition, kindly see. Para 9 of my averments made in para 9 of my writ petition. In para 9, I have categorical state several applications I have filed.
That's
no
all right,
action has been taken.
Nothing. You had to file an application before January 2020, sir.
Yes, my lord, I have given so many applications prior to that date. Prior to cut-off date, I have made several. Not a single correspondence have been made.
What you are placing on record, I'm sorry, what you placed on record is one application made on 29 December.
That is my last application, brother. That is my last application.
1 minute, sir. What you have enclosed with that is a demand draft of 21st January. All right.
My lord. Because
this has been dispatched. This has been dispatched in March 2021.
Correct, my lord. Correct.
So it's all far beyond 15 January 2020, sir.
No, that was not there. Prior to that, my lord, is fixing the cut-off date. That depositing of money was not there. Recently, they have introduced that, for which, my lord, we have paid, even if, my lord, under precautionary measure, we have paid that much of amount. Prior to that, there was no guideline for depositing of money for inspection. That is for the inspection charges. In the 2021, they have introduced. Prior to 2021, there was no charges for deposit of money. That is the sole prayer. If they have disposed of my application, let them say, yes, we have already disposed of your application.
Why should they entertain your application? It's reaching them much after 15 January.
But that is my last application, my lord. That is my last application.
Para 9. He has admitted in person. Para 9. Pursuant to para 9, pursuant to notice dated 27/11/2019 issued by DM into Orissa petition applied for issuance of cut-off date prior to illegitimacy.
Yes.
Yes, I have specifically mentioned that.
Prior to cut-off date, thereafter he has annexed that application.
Even the original requirement is it should be along with the requisite fees.
Yes, madam. That 15/1.
The deposit was not there.
Yes, it was there, sir. You yourself aware.
But deposit of money was not there prior to 2021.
No, it was there, sir. It was there. Along with requisite fees.
That is applicable for the fresh issuance of NOC, fresh NOC.
Yes.
That is for
the renewal revalidation. Sir, please don't. You look at your own government in para 9. You are arguing contrary to your government. These are applications for renewal and revalidation.
My lord.
And it had to be accompanied by fees. This is your own government.
My lord. That deposit, my lords, who have made.
Sir, you have not placed on record any such copy of any application made prior to 15 January, accompanied by fees. You have not placed.
My lord, I'll amend my writ application.
No. We are not permitting.
I'll amend.
Sorry, sir. No. You withdraw this petition if you want to.
File better.
To withdraw this petition with liberty to file a better petition.
Better petition.
This post office withdrawn with liberty is paid. Yes.
Item 48.
May I please, Your Lordship? My lord, the petitioner had availed a loan, my lord, of rupees 3,50,000 in the year 2006. He had been paying the loan continuously, my lord, and by the date 29, 2013, my lord, the amount was 1,89,000. And he had a, my lord, LIC, my lord, mortgage before the
What
bank.
is the amount due, sir? What is the total amount due?
The amount due is not disclosed, my lord, because
If you
1,50,000
don't
LIC.
know, we don't know, we can't help you. All right.
My lord, Annexure 4 is there, my lord. I have
No,
filed the
everything will be there. If you are not able to tell us what is the amount due, we cannot help you.
But they have not noticed in the demand
All
notice.
right, then we will all remain happy, sir. You will remain happy. We will be happy. No need to pass any order.
My lord, I have filed one representation under Annexure 4.
No. This is not that kind of matter, sir. This is surfacey. Everything can't be representation.
My lord, surface is my lord, issued in the year 2014. You lordship may kindly see Annexure 2.
Sir, anyway, unless you tell us what is the amount due, we are not going to pass orders.
Lord, I have instruction to appear on behalf of the bank, my lord. Now, my lord, the outstanding is about 11 lakhs, my lord.
Sorry?
My lord, now amount outstanding is 11 lakh.
All right.
Your lordship may dispose of that Annexure 4, my lord, for OTS. And
No, sir. Unless you make a payment, we won't pass orders. You be prepared to pay at least 4 lakhs, 30%.
But I will take instruction.
The petitioner seeks time for instructions on whether the petitioner is willing to pay at least rupees 4 lakhs for directions to be issued to the bank for considering her OTS proposal. At his request list before the roster bench on 10th February.
A copy of the writ petition may be sought, my lord.
Or copy of the writ petition be served on the consul of the bank.
Item 49.
May I please, Your Lordship? My lord, it's a surface matter. Annexure 2 is the notice under section 13 of the Securitization Act. And my lord, thereafter the petitioner, in fact, the husband of the petitioner had obtained the loan for the transport business, and after suffering from cancer for a quite long period, my lord, he died. Thereafter, my lord, 13th notice was issued, and the petitioner approached the bank. Thereafter, my lord, the refacement was made. As per the refacement, my lord, the petitioner has to pay a sum of rupees 85,000 per month. My lord, after refacement, my lord, she was paying regularly, but due to COVID, my lord, some problem arose. For that, my lord, 5 to 7 installments have been defaulted, my lord.
What is the total amount due?
My lord, the total amount due as per the 13th notice is around 82 lakhs, my lord. And my lord, the application of the petitioner at Annexure 3 for OTS, my lord.
Is she prepared to pay anything now?
My lord,
you know what you just heard us say in other similar matters, so you should be ready.
Yes, my lord, that I am. My lord, your lordship may say, my lord, at least 10 lakhs he will pay for application, because my lord, he is not in a position to pay anything, my lord.
That's the whole problem. Then why simply say 10 lakhs on her behalf, and you don't even know whether she can pay or cannot?
No, my lord, I had talked with her, my lord. I had talked with her. She is agreed to pay the defaulted installments, my lord.
That won't do, sir. You're now at a stage of matter going for auction, right?
No auction has fixed, my lord. 13 for notice has not been issued.
All right. Then you're premature. The whole repetition is premature, so then.
But because at any moment, they may take the physical possession. That is my only residential house. That is the whole difficulty.
Then you will be prepared to pay. What is the total amount due as of date, sir?
And the total dues, my lord, as per 13 to notice, that is on dated 8/7/10.
No, you've not made any payment after that.
No, my lord, she has not paid, my lord.
So 83 lakhs.
Yes, as per the notice, 82 lakhs, my lord, it is little bit high. It will be little bit high.
So even 1/3 will take you to more than 25 lakhs. So you be prepared to pay at least 20 lakhs, sir. When will you pay 20 lakhs? You'll have to take instructions.
I'll take instruction.
Counsel, the petitioner wants time to take instructions on whether the petitioner will be prepared to pay at least rupees 20 lakhs to the respondent bank to enable the court to issue directions to the bank to consider her OT's proposal at his request list on 11th February before the roster bench.
Item number 50.
OP number 4 is a defaulter with the bank. Now the bank under the SARFAESI Act initiated process. Sale notice was published. It was publicly auctioned. The petitioner participated. Below deposited 1,04,80,000. Then sale certificate, your lordship would kindly turn to page 23. Page 23 of my brief, my lord.
Yes.
Sale certificate has been issued to the petitioner on deposit of the entire bid value, my lord. Now the collector is interdicting the SARFAESI process, has passed an order.
So let it go before the roster bench. We'll keep it on before the roster bench. List before the roster bench on 8 February.
Yes.
Item 51.
I please, Your Lordship. Your Lordship may kindly turn to page 17. That is that matter which relates to the admission to the postgraduate medical selection 2021-22. Also, kindly come to page 17.
My lord, I have filed the counter
Yes.
yesterday and given a copy to him.
I've got the cup. I will rely upon that counter.
He has filed a rejoinder, my lord, some facts.
No facts. I will ignore the rejoinder. I am ready also. I will rely upon the counter. Your Lordship, come to page 17, annexure 3. This is the guideline approved by the government. This is relating to the admission to the postgraduate medical selection Orissa. Let's get it.
Yes.
Then Your Lordship may kindly turn to page 36. We both are in-service candidates. And Your Lordship may kindly come to page 36. You also see list of institutions and their vulnerability grade for awarding additional weightage for so-and-so PG medical course in the state of Orissa. The rate of additional weightage to be awarded for 1 year of completion of service. So for vulnerable grade institution, VI, you also V1, that every year percentage of mark qualifying examination to be awarded 2.5. And if you also will come to the bottom, just above the table, the newly constituted medical colleges, BBMC Balangir, we both are from BBMC Balangir, SLMC Koraput, PRMC Baripada, shall be included in V1 category. Am I clear now?
Yes.
So now you also kindly come to page 61. Page 61.
So you get 2.5% marks.
For 3 years, that will be 7.5. That you also kindly come to page 61. That is there. That is online application on the date of registration. They have also calculated 7.5. Page 61. You also come to page 62.
Yes.
Roman VI. Total service period of in rural, tribal, backward area as per the given list for calculation of additional weightage for in-service candidate. So far as petition number 1 is concerned, 1096 days, because that is the total days. He was number of days you also see under that 1096, and additional weightage in percentage 0.50. You also get it.
Yes.
Now you must be kindly come to state 97, the impugned state 97.
Final merit list.
My final merit list. Now you also come to Abhiram Panda. That is 1, 2, 3, 4, 5. Serial 12.
Yes.
Abhiram Panda. Petition number 1.
Yes.
Weightage. You also kindly see there is a column in service category weightage. Wait.
0.
And all others have got. And if your lordship will look to the petition number 2, he is at page 99. Page 99. Pradyumna Kumar Panda. Also 0. Sorry, Pradyumna Kumar Pradhan.
Again 0.
Again 0. Now your lordship may kindly come to page 124. That is the merit list which they have prepared, 124. Because I am showing it to your lordship in view of the counter filed by them. I will show this one. 124. You will also see the bottom. One Siddhartha Das, he has got weightage of 7.5. Does he get it?
Yes.
7.5. Now your Lordship may kindly come to page paragraph 15 of my writ application. I have specifically said about this Siddhartha Pada. Page 9, paragraph 15. Does you get it? The opposite party, while preparing the common merit list in respect of in-service candidate of dental course 2021-22, have taken into consideration the corrigendum dated 27/9/2021 and have awarded 7.5% of weightage to one Siddhartha Das who has passed out from so and so Baripada, PRM MC Baripada. We are from Balangir and Baripada, both starts on the same footing, 7.5. And such action of the opposite party in the matter of the discrimination. Now I'll show your Lordship, before taking the counter, I'll show your Lordship when the process of selection was started. That is at page 60. That is at page 60, page 60. Then I'll take your Lordship to the counter. Tentative schedule revised, page 60. Lordship, see, this was started on online registration by the candidates. PG Medical Counseling and Admission Orissa 2021-22 started from 14/1/2022. Let's get it at page 60.
Yes. Yes.
That was started from 14/1/2020. Now you also see the counter. Counter they are filed only after your intervention. They filed the counter. That is a paragraph 4. In paragraph 5. Let's come to paragraph 5. Page 4. Internal page 4 of the counter. Page 3. That is, I think, it is really page 3, not 3. It is page 3 of the counter. Paragraph 5. Does he get it?
How can the corrigendum be effective prospectively?
So far, you also kindly see the corrigendum. I'm showing that. So,
So they simply treat it as prospective.
Yes,
what does that mean?
And that.
What does that mean? Yes, Mr. Monty.
Yes, my lord, my lord, my lord.
What is this way of the whole corrigendum is so that it is applicable right away? That's why you issue a corrigendum.
My lord, the real problem in this case is the 16 notification was notified. Last year also that was not been added, these 4 medical colleges.
So what, sir? Now that there are 4 medical colleges, you should give
Yes, my lord. No, my lord, what has happened last year?
Let it go back to the selection committee. You don't accept this explanation. It has to go back.
Okay, my lord, we will give them percentage and give it. No problem.
Yes. You say the grievance of both the petitioners.
I got a judgment of your Lordship in Delhi High Court. Exactly the same point. After the process of admission was started, how can they?
Yeah, both of whom belong to the
B1 category.
BBMC.
BB Medical College.
Yes, BBMC Balangir.
Bracket BBMC Balangir. Is that the weightage supposed to be given to them as in-service candidate in terms of a corrigendum issued on 27 September 2021 in respect of the BG Medical Counseling and Admission Odisha 21-22 has not been implemented. Paragraph, a perusal of the corrigendum indicates that students belonging inter alia to 4 medical institutions are passing out, students passing out from 4, their MBBS from 4 medical institutions.
No, my lord. No, my lord. This is just working in those medical colleges. In service.
Yes.
The candidates working in 4 medical colleges.
Sir, 3.
3 medical colleges.
3 medical colleges, including BBMC Balangir, were to be given additional weightage of 2.5% per year by treating the said institutions as belonging to the V1 category. The method of calculating the weightage was also specified. and worked out for the 3 years to be 7.5%. Full stop. However, when the final merit list was published, vis-a-vis these two petitioners, the weightage given was single quote 0, which was obviously a mistake, and which led to the filing of the present petition. Paragraph in reply to the petition, it is stated by opposite parties 2 and 3 in para 5 that the committee which met on 22nd and 24th January 2022 decided to treat the corrigendum to be single quotes prospective, unquote, and therefore proceeded to prepare the merit list on that basis without giving effect to the corrigendum. Paragraph, having heard Mr. Rautri, learned senior counsel for the petitioner, and Mr. Rajani Mohanty, learned counsel for the opposite parties 2 and 3, the court is
one, my lord.
Sorry, opposite party 1. The
I
court
am
is
for one, my lord.
Sorry?
I am for one, my lord.
Mr. Kuntia and Mr. Kuntia for opposite party number 1. The court is of the view that the approach of the selection committee was erroneous. The purpose of issuing the corrigendum was precisely to extend the benefit of weightage to the in-service candidates belonging to the aforementioned 3 institutions, including BBMC Balangir, and not to deny them the benefit for the present ongoing selection. The very object of the corrigendum has been defeated by the above approach of the selection committee, which is accordingly rejected by this court. So the net result is that the case of both the present petitioners will again be considered by the selection committee, and they shall be given weightage of 7.5% each in terms of the corrigendum issued, and a fresh merit list shall be prepared and released not later than
Today is the last date. Yeah.
today itself. Today itself. Full stop. The selection committee will be informed of this order by Mr. Mohanty immediately for them to take appropriate action without waiting for the certified copy, a downloaded copy of the order, which anyway will be made available before 5 p.m. All right.
I do blame.
The writ petition is allowed in the above terms.
Item 52.
May I please, your lordship? This is related to, my lord, enhancement of royalty.
One type it up so that we can correct it and upload it. Just call someone else. Yes.
May I please, your lordship? This is the enhancement of. Your lordship.
Yes, Mr. Nayak.
Yes, your lordship. This is a enhancement of royalty, your lordship, and the second round of litigations where the executive engineer recommended the refund, and your lordship has identical matter. Your lordship page 47, your lordship.
Yes, Mr. Das, you're appearing.
My lord, my humble submission is that in the certificate furnished by the petitioner at page 3, my lord, the petitioner stated that he has approached this honorable court in 14072 of 2021, and I had also gone through that order. Your lordship has already directed the engineer to refund the amount by order dated 2nd of 7th 2021.
No, that is related to other tahsil office. That is different tahsil.
But my lord, I found that the agreement was same and the petitioner.
Yes. Yes, my lord. What my learned senior submit is correct, my lord. One agreement, this royalty was enhancedly, my lord, deducted by the same executive engineer, but deposited in 2 different tahsil, my lord. One, your lordship has already passed an order. This is for Bari tahsil, your lordship.
All right. All right.
Only tahsil number, tahsil office name may be changed, your lordship. That is in case of Dhamnagar, it is Bari, your lordship. Page 47, your lordship.
Or in page 47, change the name of the tahsildar to Tahsildar
Bari, your lordship.
Bari, B-A-R-I, District Jashpur.
Your lordship, your lordship. And the executive engineer, it may in place of Jashpur, it is be Lord Jaroka Irrigation Division.
Executive engineer, Jaroka Executive Division. Right.
I love that.
Item 53.
Your Lordship, am I audible?
Yes, please.
Your Lordship, I appear on behalf of Mr. Shashwat Acharya. Your Lordship, due to some medical emergency, he just left, Your Lordship. So kindly.
All right.
Court
Counsel, the
adjournment
petitioner
is.
is in some difficulty today. List on 8th March.
Your Lordship, this matter relates to some emergency, Your Lordship, of urgent nature. So a short next week, kindly, Your Lordship. It is
All right.
humbly
List before the roster bench on 9th February. All right.
obliged, Your Lordship. Highly obliged.
Item 54.
May I please, Your Lordship? May I please, Your Lordship?
Yes, please.
My Lord, here the petitioner has prayed for, my Lords, for a direction to the opposite part number 1, my Lords, to issue NOC to the petitioner, my Lords, for a grant of permission to export river sand, my Lords. My Lord, the petitioner is an exporter company, my Lords. Right,
my Lord, may I be permitted to submit one thing, my Lord? My Lord, may kindly see Annexure 4 at page 38.
Yes.
This letter has been sent by the mining department of state government mining department to the revenue department and disaster management department to consider his application.
Yes.
And your Lordship can direct the revenue and disaster management department, that is opposite party number 3, to take a decision on that. And after the decision is taken, if it is in favor of the petitioner, it's well and good. If it goes against the petitioner, he will file it. That decision has not been taken. That Annexure 4.
Annexure 4 is a letter from the Director of Mines to the Undersecretary, Government of India.
No, your Lordship may kindly see the body of the letter. That the file has been remitted. The matter regarding lifting and selling of river sand is being dealt by Revenue and Disaster.
Transferred to the Revenue and Disaster Management Department. All right.
Transport to the Revenue and Disaster Management Department for further action.
All right. It is seen from a letter dated 5th August 2020, written by the Director of Mines, Orissa, to the Undersecretary to the Government of India, Ministry of Mines, bracket Annexure 4, bracket, that the matter regarding lifting and selling of river sand is being dealt with by the Revenue and Disaster Management Department, and that the petitioner's letter with the enclosures were being transferred to the said department for further action.
Letter with enclosures for grant of permission for the export of river sand.
Enclosures for grant of permission to export for transfer to the said department. Yeah. Paragraph. A direction is accordingly issued to the secretary.
No, my Lord, opposite part number 3, additional secretary to government, minor
additional
minerals.
secretary to the government, bracket minor minerals, Revenue and Disaster Management Department, Bhubaneswar, bracket opposite part number 3, to examine the aforementioned letter with its enclosures.
Yes.
In regard to the petitioner's application for permission to export river sand, and to communicate to the petitioner the decision not later than 14th March.
My Lord, 2 months time may be granted because in first week of April we will come.
All right. Not later than 11th April 2022. A copy of this order shall be produced, downloaded copy of this order shall be produced before opposite party number 3 by the petitioner not later than 14th February 2022 for appropriate action. The decision of opposite party 3 be taken preferably after giving the petitioner a hearing. Paragraph. If aggrieved by the decision, will be open to the petitioner to seek appropriate remedies in accordance with law. The court clarifies it has not expressed any view in the matter. The petition is disposed of in their workers.
Item 55.
May I please, Your Lordship, my Lord? In this case, the petitioner has challenged the auction sale conducted by the opposite party bank and issuance of the confirmation auction sale under Annexure 123 11/2021, my Lord. As per auction notice at page 57, the outstanding dues is 49,70,000 rupees. I am already deposited 5 lakhs before the date of auction, my Lord. I am ready with the demand draft of rupees 50 lakhs. In the meantime, as the auction sale has been made and the physical possession has been taken, the bank is not accepting my money. And I have no only residential house for my survival, my Lord. I am ready to pay the whatever interest amount within 2 months paid on the deposited amount of the auction purchaser. I want to pay, my Lord. So for the validity of auction sale challenge before this court on the ground that the auction notice has been published without material particulars.
No, but auction purchaser has not been made party. Oh,
I have made
party number
party.
4.
Four with the auction purchaser, who has
this
not deposited 25% on the date of auction sale also. My lord, earlier I have approached this on court. My lord,
No, even today he is not deposited.
that has to be explained by the bank counsel. My lord, Mr. Bhaskar Panda is appearing, sir.
Yes, Mr. Panda.
My lord, I am pardon, my lord. The auction purchaser has deposited the entire amount. Possession has been delivered, my lord, and sale confirmation has been made, my lord, on 29/1/2022, my lord. And what the petitioner is submitting, my lord, he has not disclosed the real fact. Earlier, by WPC number 21/444/21, dated 30/11/21, my lord. Earlier in that petition, this honorable court granted interim order. Without leave of the honorable court, the bank was directed not to take finalize the bid, my lord. Thereafter, this honorable court, by order dated, my lord,
I have annexed page 60.
Just a minute. 8
70 is the order, my lord. I have annexed that order.
8/11/21, this was directed to deposit rupees 30 lakhs towards show his bona fideness within 1 week. He didn't comply the same. Thereafter, by the order dated 30/11/21, this honorable court dismissed the writ petition. Thereafter, the bidder was intimated to deposit the 70% amount.
Too late.
And he,
Mr. Satpathy, it is too late in the day now.
No, my lord. I have not in late, my lord. The writ petition filed at page the order, page 70 is the order. Previous
Mr. Satpathy, the buyer has paid the entire amount. Possession has been
But
delivered to him.
I am not on the right of redemption.
You may not be. You may not be on anything, sir. But we will be. We will have to take into account all facts. You may not be on all those facts because it's
I have
not
brought this
convenient
back,
to
my
you.
lord. Page 70 is the order, my lord. Previous order. In the previous writ petition, what I have challenged.
This round you have approached too late. You've woken up too late.
No, my lord, I am not in late, my lord. In view of the Supreme Court, my lord, the auction can be challenged till the delay in filing the essay is condoned till 18/2/2022, my lord. I have no opportunity to file the essay before the DRT Cuttack, since there is no presiding officer since long, my lord.
Doesn't matter, sir. The purchaser has purchased, he's paid the entire sum.
If the purchase is valid, my lord, if the purchase is valid, purchase is justified, then he has the right. I have only to show my bona fide. I have to clear the.
No. You're mistaken on that, sir.
No, I am not. My lord, I have to try and convince you, my lord. How this auction is bad in the law. I want to convince your lordship subject to your certificate. The auction notice pays, my lord, kindly have auction notice. My lord, kindly have auction notice, page 57. The auction notice issued indicating the detailed particulars of the property. They have not disclosed the detailed particulars of the property.
Yes.
Thereafter, the amount has been reserve price has been fixed 83 lakhs, and as per the confirmation letter under Annexure 1, the auction sale made at 83 lakh 10,000 with a single bidder. The first, there is a non-compliance of Rule 8, Sub-Rule 7A, my lord. The Sub-Rule A says the description of the immovable property to be sold, including the details of the encumbrance known to the secured creditor, has to be shown, my lord. In this case, the details of the property has not been reflected in the auction notice. The 4 crore valuation of a building, 4-story building, has been sold at a throwaway price 83 lakhs only. And in the third point of the illegality in the auction is that the sale confirmation issued on 23/11/2021 under annexure shows that the 25% of the bid amount has not been deposited by the bidder on the date of auction. That is the mandatory requirement, my lord. Rule, my lord, I am placing that rule, my lord. Rule 9, Sub-Rule 3. On every sale of immovable property, the purchaser shall immediately on the same day or not later than next working day, as the case may be, pay the deposit 25% of the amount of the sale price, which is inclusive of the earnest money deposited, if any, to the authority officer conducting the sale. And in default of such deposit, the property shall not be sold, shall be sold again. The auction purchaser who has to deposit the 25% money on the date of auction, that is 10th August 2021. They has not sold. The said amount has not. There is a clear defense of the statutory requirement and the consequence prescribed in law at sub-rule 4. If he has failed to deposit that 25% of the EMD amount, then the consequence is the forfeiture of that. The second contention, as objected my senior, that I have approached in this earlier occasion, what for what relief. I have filed that order at page, my lord, page 69 is the judgment 70. Earlier, I have applied for OTS. OTS amount was sanctioned for rupees 62 lakhs on 19th April 2021. And they have granted 3 months time till June 2021. And I have paid the upfront amount 13 lakhs. The remaining 52 lakhs has to be paid within 3 months. Due to the COVID-19 situation, I could not pay dues and I prayed for extension of time. The bank cancelled my extension application. I have approached only to the extent for extension of my OTS amount. And that has been considered by this court and notice has been issued. And in that case, I have not challenged that auction, my lord. And my lord, only for non-compliance of the directed amount to be deposited within 1 week, 30 lakhs within 1 year, this court dismissed my application, not granting the OTS benefit. So far as the confirmation of sale order dated 23/11/2011 is the subject matter of challenge before this court. My lord, I have annexed the Honorable Supreme Court also when there is a my lord, page, my lord, 83, as the DRT is not functioning, I have to approach before your leadership challenging validity of the auction sale. And there is a clear 3 statutory violation committed by the bank in conducting the auction sale. A 2,400 square foot plinth area having 4-story building has been auctioned at 83 lakhs and central located at a Cuttack town with the land value is about 46 lakhs as per the benchmark valuation report I have annexed, my lord.
Anything else, sir?
My lord?
Anything else?
No, my lord. My submission is that validity of auction has been challenged before your lordship in this writ petition. And I have disclosed in my writ petition by referring to the government guideline, the value of the auction the property is near about 2 crore. And they have not indicated in the land how many land they have sold in the auction. The auction note is silent total to that way.
All right. All right. Writ petition is dismissed. We'll pass the detailed order. Come back. We'll come back after lunch.
I may pardon, my lord.
Yes. Yes.
I'm appearing for on behalf of respondent. A copy may be served on me,
Yes,
delay
yes, they'll serve
petition
it to
copy
you.
and as well as a
You
writ
accept
appeal.
notice? Yes. Have you filed any contempt?
No, no. I have yes, my lord. I have filed a contempt. After that contempt order, they have filed a writ appeal, my lord.
So don't proceed with the contempt till the next
Contempt has been disposed of, my lord.
Sorry?
Contempt has been disposed of. The
All
further
right.
direction
Just
was
notice and stay
given
also.
for.
All right. He accepts notice. List before the roster bench. 20th April, 20 April.
Item 59.
May kindly stay of the interim order, because otherwise they will again reiterate the content.
Item 59, my lords, may be permitted to withdraw as not pressed, my lord.
Counsel for the petitioner seeks leave to withdraw this petition as not pressed. Dismissed as withdrawn.
Item 60.
May I please, Your Lordships? Your Lordship, in this matter, the department has issued the letter under in the form of a recovery order, Your Lordships. Because kindly have a glance on the impugned letter that is at Annexure 2, Your Lordships, page 61, Your Lordships.
Yes.
Page 62, Your Lordships, directly they have issued a letter, but at the page 62, the last paragraph, Your Lordships, therefore, may I place, Your Lordship, that paragraph?
Yes, please.
Therefore, it is requested to pay the interest due as mentioned above within 7 days of receipt of this letter, failing which necessary action will be initiated under the provisions of Section 79 of CGST Act 2017. Lordship, Section 79 is the recovery of tax, Lordships, recovery proceeding. So, without any so-called notice, they have issued a letter. The first part of the letter says that we request you to pay the due interest amount. But under the guise of a letter, they have already issued a recovery order without any so-called
Yes, Mr.
notice.
Sharma, who's appearing? Mr.
I think
Mishra?
Mr.
Sunil Mishra?
No, it also this is CGST matter. I think Mr. Chimanka is appearing.
Yes, my lord, I am appearing.
You have any instructions, Mr. Chimanka?
I have filed the counter, my lord. Section
Alright.
50.
You already filed counter? Yes.
Yes, my lord.
But no copy has been served on me, Your Lordship.
Oh, you see, notice Mr. Chimanka accepts notice on behalf of opposite parties 2 and 3. 2, 3 and 4. Full stop.
Yes, yes.
He has already filed a counter affidavit. Copy thereof is served on counsel of the petitioner. rejoinder be filed by the next date. Till the next date of hearing, no course of action shall be taken against the petitioner. List on 4th May before the roster bench.
Obliged, Your Lordship.
61. Muted.
Ms. Roy Chaudhary, 61.
I was muted. Sorry, Your Lordship.
Your
Lordships, admittedly, I have challenged the order in original. Liberty may be granted to file appeal, Your Lordships.
All right. Counsel, the petitioner seeks leave to withdraw the present petition to file an appeal in accordance with law. Disposed of is withdrawn with liberty is prayed for.
Deeply obliged, Your Lordships.
Item 62.
May I please, my lords? So I'd at the outset humbly pray that the defect as pointed out, that is 7 small Roman 2, may kindly be ignored. This
All
is
right.
the capital letters.
All right.
And the similar matter, my lords, for another quarter has been listed, directed to be listed on the 7th of this month by the roster bench. That is WPC 20568 of 2021.
All right. Notice list along with 20568 before the roster bench on
7th of February.
7th February. Oh, that's Monday. All right.
That's Monday. May I humbly pray, my lord, there are 2 other similar matters belonging to 2 other quarters. These 2 matters may also be listed. That is WPC 20214 of 2021 and 20390 of 2021.
Both taken on board, notice and list of the roster bench.
7th, it has been directed.
All right.
Much obliged. Much obliged.
All right.
Lordship, item 63, Lordship. I pray 2 weeks time, Lordship.
Okay. Counsel, the petitioner states that he will remove the defects within 2 weeks. List thereafter.
Lordship, obliged.
Before the roster bench.
64.
Yes, Your Lordship, this is a surface matter, my lord. My lord, I was tested positive since last 13 days.
All right.
So
Counsel,
I
the
cannot
petitioner states that he is unwell. List on 15th February before the roster bench.
obliged. Much
In
obliged.
this matter, they have not served the copy of the lead petition, my lord.
I will serve it.
Item 65.
My lord, item 65. My lord, I may pray kindly allow to 1 week time for removal of defects.
Counsel, the petitioner states that he will remove defects within 1 week. List before the roster bench thereafter.
Item 66.
My lord, item 66, I am appearing for the petitioner. My lord, similar matters have been disposed of by a coordinated bench of this honorable court. My lord, I have given a memo. This matter may be disposed of in that light, your lordship.
Who's for the MCL?
My lord, Mahanadi Coalfield Limited.
No, who's appearing for them? All right. You say in view of the dismissal of writ petition number 30958 of 2021 by the order dated 30/11/2021 of this court, this writ petition is also dismissed. All right.
Item 67.
Lord, this 67, the defect pointed out that the copy has not been served in the meantime. I have served the copy.
Yes, I have received the copy.
Lord, I am challenging the appellate order. In this case, Lord, the same notification was challenged in 2 writ petitions before your lordship.
Yes.
That is WPC number 13582 of 2021. Your lordship disposed of that writ petition on 3/12/2021. And the present writ petition, where the appellate order has been passed, your lordship directed the collector in that case to hear the appeal. And after hearing the appeal, the collector has set aside the advertisement. That in respect of that 2 Sairats, Lord. I will file that order before your lordship by way of an affidavit, and your lordship will take up one in the next week.
I think that matter is not directly
related. The same advertisement was challenged.
But that is different side. Different side.
File that affidavit of the collector.
All right. Anyway, at the request of counsel, it's okay. At the request of counsel, the petitioner list before the roster bench on 9th February.
Yes.
Item 68. 68.
1 week time to remove the defects.
Counsel, the petitioner seeks 1 week's time to remove defects. List thereafter.
Item
seeks and is granted 1 week's time.
Item 69.
Please, Your Lordships. Your Lordships, in this matter, my learned brother, Mr. Chimanka, needs a offline to serve the copy offline, Your Lordships. So I may be permitted to serve a hard copy to Mr. Chimanka within
All
2
right.
days, Your Lordship. Next week, it may
Copy of the petition be served on Mr. Chimanka, appearing for the opposite party today itself. Right.
Extra copy also, my lord.
That's what. List out for the roster bench on 16th February.
Deeply obliged.
Item 70.
My lord, 1 week time may be given to remove the defects, my lord.
Counsel for the petitioner seeks and is granted 1 week's time to remove defects.
My
This thereafter.
Item 71.
1 week time may kindly be given.
Same order. Same date before the roster bench.
Item 72. Item number 72.
Item 72.
On behalf of Mr. G.K. Nanda, my lord, Mr. Nanda is in isolation. Kindly adjourn to any other date, my lord.
Counsel the petitioner is stated to be unwell. List on 22nd February before the roster bench.
Item
Obliged.
73.
Item 73, my lord. I have removed the defect. I have served copy. And this matter is covered by your lordship's order dated 3/8/2021. I have supplied the soft copy to the court master.
Yes, it is a covered matter. Your lordship has passed several orders.
All right. Same orders.
My lord.
All right.
My lord, can I file a fresh representation?
Whatever is there in that order, sir. Right.
Item 74.
May I please, my lord? My lord, this is in this case the petition happens to be a partnership firm, and in this case the assessment was completed under section 143, which suffered appeal before the appellate authority, who allowed the appeal of the assessee. Thereafter, department filed appeal before the Honorable ITT Cuttack Bench Cuttack, which was dismissed. Assessee also filed appeal before the ITIT, which was allowed. And thereafter, a notice under section 148 has been issued on the very same issue, which is also time barred. The assessment here is 14-15. It has been.
I think those cases are coming on 7th March.
Your Honor, that is not required because in this case, the fact is, even if the TOLA, that is tax and other law, that has extended the time limit, and assuming and presuming that the law application of law is also extended, still it is time barred by beyond 6 years, so cannot be sustained. 148 has to be quashed.
Yes. Who's for the opposite side?
Yes, my lord, I am opposite.
I
will file the counter, my lord.
We say notice, Mr. Chimanka accepts notice to the department. Reply be filed within 4 weeks to the next date. Till the next date, no coercive action be taken.
Obliged.
On 14 March before the roster bench.
Obliged. Obliged. Much.
Item 75.
Yes, item 75, Milords, defect I have already removed because copy has to be served. I have already served copy. Defect may kindly be ignored, Milords.
All right.
And so far as the case of the petitioner is concerned, Milords, petitioner in this application challenges, Milords, the ruling of the advanced ruling appellate authority, Milords.
All right.
Last under section 100 of the CGS Act, Milords. Milords, initially, the ruling given by advanced ruling authority, Milords, under section 97, which your lordship will find from annexure 1. It starts from page 30. There are 6 questions, Milords, raised by the petitioner before the advanced ruling authority. Milords, barring one, all Milords, questions post, Milords, are answered in favor of the petitioner. Milords, the question was basically, the petitioner, Milords, deals in Milords, manufacturing of bakery items and has its restaurant where these are served to the customers, Milords, or customization, Milords, whatever orders are placed, Milords, according to taste, flavor, Milords, topping of Milords. These are Milords in provided air conditioned restaurant, and those are taken into record, Milords, by the advanced ruling authority. And your lordship may kindly see page Milords, 42. It starts from page 41.
Anyway, we'll examine it. Mr. Sahu will examine it.
Minus.
Say notice. Who's appearing for the opposite parties?
My lord, I am appearing.
Mr. Chimanka accepts notice for the opposite parties. States that he
2,
filed
4,
a reply
5,
within
6.
8 weeks, rejoinder for the next date.
Minus.
List
Extra
on,
copies. 2, 4, 5, 6.
Right. List on 9th May.
Minus.
Right.
Item 76. 76.
This matter has become infructuous. It is relating to that panchayat election,
Ah.
OBC, and Mr. Sadangi was yesterday. He was
Yes, I am there, Your Lordship.
All right. The prayer in the present petition cannot be granted since the election process is already, election schedule has already been notified. The petition is accordingly dismissed.
For admission, item 77.
Covered matter, some order, BSNL order.
I have already passed the order.
In view of the orders passed by this court
In STRV 91. STRV 91.
6th December 2021 in STREV 91 of 2019, bracket Telecom District. The revision petition is disposed of in the same terms.
Lord, I am appearing for the OP 5 and 6, my lord.
All right. All these matters.
Item 78.
78, my lord, I am for the petitioner, my lord.
Yes, please.
My lord, the petitioner availed a shelter loan from the UCO Bank of Baleshwar, my lord. Thereafter, it became NPA. And your lordships on next previous date on 17/12/2021, your lordship directed the opposite party to file a counter.
Not counter. They were to tell us what has happened to the objections.
Regarding my objection on that,
where is Mr. Swine? Mr. Swine?
They have not taken no step.
No reply has been filed.
Yes, my lord. Yes, my lord. I am for the bank, my lord. I am for the bank, my lord.
Yes. What happened to the reply, sir? You're not audible, sir. You're not audible. Neither audible nor visible.
Their ODS application is already disposed of, and my lord.
Yes. Yes, please.
My lord, on dated 27/12/2021, their ODS application is already rejected. They have not deposited any single amount before the bank.
You were to file a reply, sir. What happened?
My lord, in this present situation, the chief manager is ill and is suffering from corona.
Counsel for the bank seeks and is granted 4 more weeks time to file the reply. Rejoinder there to be filed before the next date. List before the roster bench on 23rd March.
My lord.
79. Item 79.
My lord, I am for 79. I have submitted an instruction, your lordship, to your lordship's mail.
Let's see that.
Lord, in this.
Renovation of Peta Nalla.
Yes, my lord. Renovation and maintenance. They
have sanctioned some 36 crores.
My lord.
It is being placed before the government for its administrative approval.
My lord.
When will this approval come, sir, Mr. Monty?
My lord, it is in the process. It will come very soon because now we are in the restricted period due to this panchayat election.
So we'll keep it in April. I'll note this and keep it in April. You say Mr. Monty has handed over a copy of a letter dated 25th January 2022 written by the Chief Engineer Drainage instructing the petition, the AGA, that a detailed project report for an amount of rupees 3613.40 lakhs for renovation of the Peta Nalla at CDA Bidanarsi was approved at the 136th TAC held on 14th December 2021. And the matter is now, and the proposal is now before the government for its administrative approval. List on 11th April.
Should I may be given a copy of this letter?
A copy of this communication be provided to the counsel of the petitioner today itself. List on 11th April 2022, on which date the government will inform the court of the progress in the matter.
And Miller, so far the present cleaning and maintenance, the municipality, they have already some copy of Mr. Naik. Let them directed to clean this Vitana because mosquitoes. And
Yes, where is Mr. Devashish Naik? Yes, Mr. Naik.
I'm here, sir. I've received the responsibility for the drain, and it's actually not a drain, is what I've been instructed. It was actually sort of a canal. Now it's because of people constantly dumping waste material into that, it's been converted into a drain. That maintenance of that is already, as my learned senior has proposed, learned AG has proposed, that is already a consideration. What I've been instructed is the awareness about not dumping waste materials in and around that particular area. The entire garbage cleaning the municipality is going to undertake. Undertaking, in fact, awareness is going to be, people are constantly dumping there. So there is a need for an awareness program that is supposed to be off the ground.
Mr. Devashish Naik, counsel appearing for the Cuttack Municipal Corporation, states that (CMC) states that the CMC is currently undertaking an awareness drive to dissuade people from dumping materials in the Peta Nala. The work of cleaning the Nala has also been taken up. An affidavit be filed with the CMC explaining the improvements made in the maintenance and upkeep and cleanliness of the Nala before the next date.
Item number 80.
Yes, my lord. I am for the opposite party bank, my lord.
Yes.
My lord, the order passed by your lordship on 28/1/2002 has not been complied with.
Who's the petitioner?
On that day also.
None appears for the petitioner. Counsel of the bank informs the court that the assurance given to the court on 28/1/2022 has not been
complied with.
Adhered to. The petition is accordingly dismissed.
Obligement.
Pastor matter, item number 4.
Mr. Rao is given a note.
No, not this.
May it please, may it.
Yes, Mr. Rao.
This writ application is directed against the communication in Annexure 8. What has happened, my lord? I have proposed to take the industrial unit from the OSFC. Under Annexure 1, they have directed me to deposit 25% of the total default amount. Then only they will consider my claim.
No, last time Mr. P.K. Rautre appeared.
Yes, Mr. Rautre was there in the first hour. In fact, his father was the conducting lawyer because he passed away. Your lordships have permitted him to appear and file the counter by order dated 30/3/21.
Where is he, Mr. P.K. Rautre?
He was there in the first hour, my lord.
Mr. Rautre, Mr. P.K. Rautre. All right. You say on the previous occasion, Mr. P.K. Rautre had appeared for the opposite party, OSFC. Today on the second call, he is not present. In the interest of justice. List on 17th February.
Item 11. Item number 11.
Somebody appeared in the first call.
No, Mr. S.K. Raut was mentioning on behalf of Mr. Monty.
Who, Mr. Mohanty?
Mentioned on behalf of.
All right.
Lord, I am appearing on behalf of Union of India.
All right. Counsel, the petitioner is stated to be unwell. List on 25th February before roster bench.
Item 36. Item number 36.
Your Lordship, I could not trace the file.
All right. Counsel, the petitioner has still been unable to trace the file. List on 22nd March.
Lordship.